The respondents number 2 and 3 directly paid by the petition previously and refund the total amount of rupees 22 peso within 1 month from today. With rate of 6% per annum. Interest. And cost of rupees 10,000 paid by the CFO.
Item number 10 of quota is 7. Quota 27 is not fitting.
Huh?
Quota number 27 is not fitting.
Okay, okay.
That is the ONC matter, the price, IFC mobile matter.
That
That is the urgent matter for ONC. But may I pray, I said, day after tomorrow may be taken up. I think,
Okay. That is the matter on the pair of Mr. James. What is the matter there?
certificate to move an urgent not
Huh?
urgent
Regarding?
So regarding it's a tender, my technical bid was rejected on then. So then on 11th I submitted a representation. On 14th evening, they have did not consider, they have informed that they would not consider my representation. So 15th, 16th, and 17th was a holiday, so I have filed today. So they have already opened the financial bid. Now, for till 8 p.m. of today, it is fixed for the reverse auction. And likely that tomorrow they will finalize the financial bid and the
If time permits. If time permits. Huh? New matter. Regarding what? What? One committee? What committee? Huh? What? Regarding what? Rent. Rent. Rent will not be, I don't think. Huh? Rent is a bench for matter. No. I think most probably maybe is it a bench for matter? Yes. Huh? Monday.
one temple they used to settle the one market situated to their own land. Now, what is the they are doing this. But now the government has invited tender for that market to situated to the temple area and temple's own land. So better is answer they can be taken tomorrow. Because that is turnout should be open on 20th.
20th.
Yes. So I'm not.
Okay.
But another thing, my lord, no lawyer from PNID has yet come. So we could not stop the copy, but he is coming. I will tell him on he is coming. We are signing. We are perfecting. Everything is ready.
No, it's tomorrow, so you wait for him. You wait for him. He's coming today.
Yes, he is coming.
So you wait for him. You give him the thing.
Permission, I will put the number. So he is coming. After he is coming, I will put the number. Okay. 8 people. Another very urgent tender message. The technical page wrongly rejected.
When? Rejected when?
On the 14th of this month. Technical. But on the same day, financial decree was also. Now, today is the date when they will issue the work order. The matter is very urgent. And we have had the so that the matter is.
Show me what is the filing number?
The filing number is 692 of 2024.
I don't know when is that by the time order is issued, everything will be all, it will have no use. End of justice, but you've got to think of the time limit. Let us start. 15 years.
Today, also pilot the trusting council on record also is not
The 2014 matter, Mr. Council,
That's fine.
10 years ago.
unless pilot the trusting council, also.
You are not interested in pursuing the matter, we'll dismiss the matter. Not a difficult.
There is nobody
Huh?
trust on record.
Nobody to instruct whom.
Pilot, my neighbor also not speaker of the file.
If no one is there, then we'll dismiss it for not prosecution. Why should you be bothered? You're not there.
Pilot, that is not the impact because good education. Not that's why
Who got
the
relevant?
pilot,
Mr. Goswami.
that's why pilot that is because till that time
2014.
Mr. Basalatama has filed it, this the next day pilot
Mr. What is your name?
is something.
A.
Subject.
Council. Subject that you will be filing the Bakaratnama on behalf of the petitioner today. Accordingly, in this matter after the vacation. Louder, pull the mic. Yes,
Lordship, am I audible?
yes,
Lordship,
louder.
we are challenging the clause 10 of the NIT dated 30/5/2024. Lordship, further, there is a violation of rule 47 subclause 2 of the Assam Panchayat rules, whereby they have given only 21 days. The last submission bid is the date of the submission bid is 21/06/2024. So, Lordship, the matter may be listed tomorrow for motion.
Friday.
Lordship, the last date is 21st. Today is 18th
On 20th.
of like
I'm mentioning for listening for pending contract and the person is the of 10 more. Need date may be given.
Up to the date.
under that section mention a writ petition for listing.
Pending matter.
Yeah,
Regarding
regarding tender. All the meetings have been completed, matter has not been discussed.
when was it last listed?
23,
24. What is the matter about?
my lord, we were selected as the carrying contractor for the FCI. And in pursuant to a tender where the distance to be covered was 292 kilometers, and we came to know that it was 342 kilometers. So we have submitted our bid for this, but it was rejected. After this,
Give a thing. Like exercise, I know 15, 1 5. Yes. I do not want to play this better. How you don't want to play? Mr. D.C. Bora, learned counsel for the petitioner, submits that he has received instructions not to press this matter. Mr. S.K. Roy appears for the S.S. Roy appears for the the petition allowed. That is petition dismissed or not. Oblige.
So this is case of I'm filing today.
I filing what?
If we take it with regard to what amount we have paid and how much amount we have to pay, as per our the last order. Friday, madam. As per losses,
You filed the affidavit
I
today.
filed just now, just I have
Will you give a copy?
I'll give it. Friday, madam.
Just a minute.
Losses we have paid out of 34 lakh 36,000 losses. We have paid 15 lakh 53,000 and there is a balance of the amount of 19 lakh 50,000, which is going to be paid by person.
Paid by what? When?
It pays the as far as possible.
Up to you know, when logically matters of 2018
Lots of the because of the case.
not
Because of the case, but the team has 6 months time.
first time. Right. Heard Mr. A.M. Babu, then it's counsel for the petition. And Mr. N. Upadhyay, then it's counsel for the irrigation department. The grievance of the petitioner is that the petition, that the respondents have not paid the petitioner rupees, how much?
19 lakh 42,660.
This amount, 19,42,664 for contract was done by the petitioner. Mr. N. Upadhyay, then it's counsel for the irrigation department submits that he has filed affidavit in a position today. Affidavit in a position today on behalf of the respondent number 6. Where is? It is admitted by the respondent that out of the total bill amount of rupees 34,96,445, an amount of rupees 15,53,683 has already been paid to the petition. The remaining amount of rupees 19,42,663 shall be paid to the petitioner as soon as possible. Yes, sir. He submits that the respondent will pay the balance amount within a period of 6 months from the in view of the consent of the party, this petition disposed of with a directive to the respondent to pay to the petitioner the balance amount of rupees 19,42,664 within a period of 6 months from today. The writ petition is accordingly disposed of. All right, sir.
Lordship, conflict was directed to offense, but
With the council,
the three over. Lordship, you can inform me that his instructions have not yet been.
that is, awaiting, but still awaiting instructions. But since
It's a long time, Lordship. The debate was filed in
They were-
2020.
they give it for the
Lordship, can it be on the 24th?
district law, motion tables,
Small matters only the instruction.
the instructions will not come. No instructions will come. The lordship may give it for the do a better of it. But can you get instructions by next week? But you can, do a bit. Tomorrow you do a bit. The petitioner counsel submit that the contractual bill payable to the petitioner amounts to rupees how much?
Lordship, there are two cases, Lordship, in WPC 4441.
Amounts to rupees. Give me
Lordship, it is 217,228. 2,17,228.
217, comma, 228.
228.
In WPC number
In WPC number 441 of 2020
441 of 2020. And rupees
and rupees 9,58,405.
in WPC number 4465 lot 2020. Mr. M. M. We are. Appears for appears on behalf of Mr. B. Rose, then standing counsel Peter. And submit that here they have not received instructions till it. It is surprising to note that despite a lapse of nearly 4 years, the respondents have not provided the instructions to their client, to their counsel. Still, Mr. M. We shall obtain instructions Why the big? This is the matter on 24.
Not just a small correction on my part, Roti. Roti in WBC 441,
Ah.
441,
People for what?
the amount is 18 lakhs 14,331.
18 lakh
14,331.
14, comma 331.
And in WBC 4465, the amount is Lordship 2 lakhs 17,228.
2 lakh 17,000.
228. Obliging.
Last time also you same,
Yes.
same thing.
Yes.
Huh?
Last time, here we have subsidies of this amount of
Amount not mentioned.
53 lakhs.
Huh?
53 lakhs, the total admitted liability. Here, four quarter.
Go quarter 52 lakh.
Let's say.
Where? Hey,
That is the admitted liability, page 23 is 53 lakhs.
approximate value of work is 52.92. Anyway, Ms. Avi Bora, learned standing consultation. It granted a further 2 weeks time to file affidavit the position regarding the claim by the petition for payment of rupees 53 lakh. This is the matter of Ms. Niloda appears for Bueno.
So to purchase the non-payment of contractual bill amounting to 17 lakhs 47,160. It has taken time on numerous occasions.
Huh?
Proper structure has you don't know that's difficult aside from that after the effect
After?
the said is
Been going on for some time. They have taken
One
time.
year past father.
but the second time I tried to
It just came by learned.
It will be a last opportunity.
Huh?
It will be a last opportunity.
Learned
Take
counsel
time on-
for the KSC granted 2 weeks time to
That will be 10 days.
obtain instruction and file affidavit in the police
On numerous occasions they have taken.
for the unpaid taxes. This is the matter after the meeting.
They have a date
Right.
brief.
has therefore
Issue the learned counsel for the state responsibility granted
Taking a date of.
a further 2 weeks time to obtain
one-
instructions and file it.
yeah,
Next week to nothing with that.
The teacher that other.
No hurry. What do you want? You want this is a
Because this is by this mistake of 3 days.
I do not know. You are the state government who knows best. The state
Yes,
perspective.
but they have done nothing. Just that order.
You want to feel good with the PSO around. Big
Yes,
man,
no,
big
that's part of
with
the-
PSO.
Yes, so by constitution they should recognize us. The government of-
You see, sometimes people they want PSO only for show.
That's true, Lord, but I have mentioned all the FI that I have been since 2006.
I have can see laws, but we have to see whether the
Not the recent affair, since 2006.
FIR can be fabricated also. It's not at all. You know, let them take a decision.
Okay.
It's a matter of
I'm able to start these these legs in the another product transfer for the time. After some extra then
Yes, yes, of it, yes. So, what is your prayer? What is your submission? Huh? You don't like? What to do? We have to wait. Yes, next. Wait. He was on leg in some other court. And I attend the whole case or different courses. No one appears for the petition. According to matter where there's a week. There's a matter. Yes, yes, yes. No, yes. No one appears for the petition. No one appears for the petition. There's a matter.
That's right. I'm just thinking, shall I make my argument, my lord? Sometimes
No, we've got a whole bunch of cases where we're waiting for one side or the other. From within, yeah, they're all waiting for the other side. So no point if we wait.
yes, I also don't feel like in the absence of that side to make my argument.
I don't know. He's ready.
Let's take one more data set.
Be taken some other day, Lordship, because what the topic I've given, PK Roy did not come today.
Who got on come?
PK Roy, Lordship,
PK Roy. Okay, right.
Any
General,
day.
huh?
Any other day.
The general prayer has been made on behalf of Mr. PK Roy, then counsel for the petitioner. Accordingly, this is matter after the petition. Item 20, who's here? No one appears for the petition on call. The transfer matter. Transfer, no, from the industrial tribunal. So transfer order was not interfered with.
Understand the question, because first,
Huh?
they're the main respondent, managing director, president of a- because, fire burning, because
This was the prediction from. This is the matter of the. story. Every taken up after something. All taken about something. From item 8 is all taken about something. Now what do I do till that sometime comes? Okay, sure. That's the best. Right. Timing at 12. Yes, what is your case, madam?
So appointment of perpetrator by the report. Because in fact, on previous occasion, the Honorable High Court has
Let us see the order or budget for.
Right. my lord order there is 5 to 24. So,
Page
no,
24.
my lord, that is that in that order, my lord, my list is order. In the order, my lord, that is 10/4/24.
8424.
10/4/24. One order was
Page.
oh no, my lord. It is for appointment of arbitrator, my lord. That is
Give me the main, but I will take it, predicate. Nothing.
it is for appointment of arbitrator by the Honorable Court. That's
Huh?
section 11. It is section 11 petition. So in this case, my lord, earlier one order was passed, my lord.
Where is the order?
No, we are not coming fix the order. The order is passed in this case.
Where is the order? That's what I'm asking. Where is the order?
Order is 10/4/24.
Ah.
Order, my lord. The report, para 3, which is referred to documents appended to the affidavit composition and it submitted that the respondent properties are ready and willing to appoint an arbitrator in terms of contract agreement and conditions contained. However, petitioner is failed to waive their objection on appointment
There
of
is
mediator.
notification regarding the arbitration matter. That's it. There's a new notification issue. Arbitration matters have to be listed before justice to be processed. So I don't think I can take up this. But you have got no case, madam. There are enough judgments. You cannot appoint your own officers as arbitrators. There are enough judgments. So we'll listen before the appropriate way.
Right, my lord.
Okay. Right, Mr.
Yes, sir. Yes, sir, ma'am.
No, Miss Beta, Miss
I'm
M. Parman appearing on behalf of Miss A.A.M. He appears for the applicant, while Mr. M. Parman. Oh, no, what is your name? What is your name?
My SJ, sir, ma'am.
Appears for the respondent.
Arbitration.
And this is the opposite party.
Ah, okay.
In view of the notification number 46 dated 11/6/2020, by which the Honorable Chief Justice has been pleased to nominate the Honorable Mr. Justice Pavitra Saikia to deal with applications under Section 11 of the Arbitration and Conciliation Act 1990 and the principal seal of the Body High Court with effect from 15/7/2024. Oh, this is 7. This is up to July.
So July,
This is July, no,
betterment date.
so I can put July. After. No case, madam. You want to appoint your own officer as per the arbitration law. Unless in this order also not properly made anyway. Right. Where is the arbitration clause? Where is the arbitration clause?
Arbitration clause. That is, that's page number 129 of the main petition.
129.
129 of the main petition.
Yes, which portion?
And the relevant part which they are arguing is at page number, is at clause number 64C. In the bottom matter.
CA1 or CA2?
CA2, it will be CA.
What is the claim?
CA2.
What is the claim amount?
Claim is above 10 lakhs.
What is the claim amount? I know it's above 10 lakh. What is
Right.
the claim amount made by you?
It is 26 lakh 91,000.
26 lakh 91,000. Yes, madam.
Regarding the appointment of the arbitrator from
Yes,
previous
yes. Where is the order?
Hatia Door Private Gujarat Private.
Order dated
That is
Huh?
Article 5 of 2023,
5 of 23,
dated 5/2023.
5 to 24.
Yes.
Can you give me a copy? Then what is your view then? I think that those easement perkins, all those people judgments are there. Perkins easement, yes.
To find activity.
Huh?
If there is a upper case to find activity, that's not probably.
I know, that is there. But till that time, that SLP decided by the Supreme Court, then you have got to follow the law. For railways, I know they're planning to do it separately. That's correct. Third, with a gap, learned counsel for the applicant, as well as Mr. Spencer, learned counsel for the opposite party. Huh? I can do that. If both of you agree, no problem.
solar system level.
You are doing the main case. I doing the main case. Huh? Heard Mr. Spencer first, huh? Then and Miss and Miss Ahab for all the respondents. Number 2, this is this application has been filed under section 11(6) of the Arbitration and Conciliation Act 1996, hereinafter referred to as the Act. for appointment of arbitrators, for appointment of an arbitrator, which has been occasioned due to non-payment of bills by the respondent. Correct? The, you have already appointed your arbitrator.
No, my.
Correct?
Railway has appointed her.
We have a
Okay, railway
They have
appointed
attended all the.
in terms of that.
They have.
So that's why you came
Yes.
challenging that.
Yes.
But you have not challenged that.
Actually, what happened, my lord? They asked us, to web the complaints of order, section 12.5, 12.5. We refused it. We refused. And after refusing, we have come to the conclusion that they are not a convenient, the independent required, independent arbitrator. Thereafter, my lord,
Did they appoint anyone?
yes, they appoint. The evidence their affidavit indicates that they appointed one arbitrator, but that arbitrator also resigned from the office, stating that it is an illegal appointment. I cannot see. If you are appointing your officer, that is in their affidavit itself.
Then what happened? Then what happened?
Then nothing, my lord.
they approach Kota.
They approached the court and matter is pending before council court.
So no, you see, Mr. Council, one thing is, okay. Okay, but the facts of the case in brief is that due to a dispute between the parties with regard to the contract work being undertaken by the petitioner, comma, the respondent appointed an arbitrator.
Panel of three arbitrators.
Where is that order?
I don't.
Page in
My
your
lord.
petition.
My lord, may see. Actually, panel of arbitrators, my lord,
Mr.
Yeah.
Council, please understand what I'm asking you. Where is the order appointing the arbitrators?
my lord, I am coming.
You don't know anything. You don't even know your own case.
My lord, actually, it's filed by them, my lord.
This,
My lord.
this,
Madam,
this
Madam.
35 is filed by them or by you? It's
Madam.
by you.
I'm coming.
PCM Cement Concrete Private Limited is the petitioner, is you. It
Madam.
is not the Union of India.
Madam.
What do you mean filed by them?
My lord, may kindly please come to page number
You
25
will
of
take
the
it up. You please read and please get the date.
page 25 of the IAI.
We please ask for something. You please read your case.
Madam.
Get to know the facts. I don't recall. Since that, we say all the, yes, regarding the notice. No, I will just, where is the corrected IA? Is there any IA? Additional, no, additional affidavit. Yes. So regarding the notice of the CMC, by which my major paper system was. Now, your lordship's query was on the, even on the first date and on the day of which the notice was issued. That's the extension of your permit. Where is that? That is at page 137 and 138 for both the demand. Where is this? My lord, this is certificate awarded to Hillview Bed and Breakfast. The flat number is mentioned.
And at the very bottom, your lordship will see it issued on 6th of June 2024 and valid for 2 years.
Yeah.
That is June 5, 6, 2026.
Okay. Yes,
Street license, they have to take out a trade.
Huh?
They have to take out a trade license.
show me under what provision?
Why not? What's the
Have you filed any affidavit? You're not filing anything.
I have my instruction.
Huh?
I have received my instruction, madam. Profit transfer page number 252. Thank you. I have filed.
252 years.
What a mutual corporation, such a regulation,
Huh?
hotel, boarding houses and houses, restaurants, king and friends of bylaws number 2020. And it will. Yeah. Fine. Number 4.
But bread and breakfast is not there.
Wait and discuss is a new concept. This is not even establishing what these are all actually relying in the Delhi.
So-
It also comes in the, when there is a boarding that it comes because personal go there, stay there, next day or whatever they have to go. And eating is also there. So it acts also towards that particular housing, hotels and all. They have to take out a trade license.
Yeah. So you have got the instructions. Look, I've got it. So you file an affidavit. In the meantime, let them run the bread and breakfast.
Trade license, they have to take it.
No, they take it under which provision?
Why not? Paragraph, let us say number 4, my lord.
Huh?
That's clause number 4.
Yes.
No places within the municipal limits of the city shall be used for except so and so, so and so, so and so, so and so. Residence. With the public places without taking out a license from the commissioner or other office appointed on the empowerment of by him and in the on behalf, and as such license shall be remain in force from the date on which such granted till 31st following may be renewed. But as per section 180 of the Act, there is a trade license, we have to renew it every first week of April. Trade license, they have to take it out at it. And this Act, the bylaws also covers that particular, whether it's a sale or it's a place where the one is going to stay.
Trade license under which provision?
Section 180 of the Act.
Which act?
The GMT Act, that will turn to page number 80. Page number 80.
Yes.
Every person who is exercised or carries in the area inaccessibility, either by himself or by the event, any of the profession, trade or college, indicated in the fourth cases, shall be annually take out their license before the first day of April in each year. So within 1 month of taking out the day of the profession, of trade or college, that the case may be the presence of the fees of the in the above. They have to take out a trade license. Without trade license,
Mr. Council, is there a trade license for bread and breakfast?
the paid and breakfast,
Tell me what trade license with respect for what they will they take. You tell us specifically, then they'll apply for it.
well, they have to apply as a guest house member. It's a guest house.
You see, does your portal provide for this bread and breakfast? Does it have a provision? It has it to be done online,
Yes, there are provisions for online also, offline also.
offline also.
Also offline.
Offline, they can ask for a bed and breakfast offline.
They can access for better.
Huh?
Offline also they can apply.
It has to be specified in the schedule. My friend is reading from the book. There's the schedules are there. They don't read it. No way is it mentioned.
2017 Act, my lord. 2000. Bed and breakfast is a new concept, not even.
So you make provisions for that in the government of India speaking.
Act they are relying in the Delhi way. No, that I have given as an example. That have to be given. The guideline is of Delhi way. That guideline is for
Mr. Council, just show me the format under which they have got to apply for this bed and breakfast establishment.
That's why the trade license has to apply.
Right, correct. But when there is a provision for that particular bed and breakfast, if there is no provision, then what happens?
They have to apply the guest house method.
Huh?
Guest house. Because
The
the
guest
Act,
house.
Act 1976 Act also comes within that guest house. Because guest is coming there, they're staying and having the food and not. This is guest house is under.
Let them file affidavit. Let them, otherwise he just saying things which just come straight away. We cannot even, we cannot hold them to their promise.
Well, let's why it is not to allow me 1 week time. In the meantime, I will explain.
Oh, no.
If you waited for so long, well, that's
No, they waited for so long because this was questioned them. Now they've cleared that. Right,
1 week time.
Mr. Chief Bharadwaj, Learned Counsel for the petition. And Mr. P. Bora, Learned Counsel for the GM,
All the
for the older. The petitioners have put to challenge the impugned notice dated 20/01/2022, by which they have been asked to close down their bed and breakfast establishment on the ground that the trade license under section 180 of the GMC Act 1971 for establishment of homestay has not been taken. The petitioner case is that the bed and breakfast establishment has been registered under the Ministry of Tourism of the Government of India and have been possessing a NIDHI certificate of the state authority. He submits that the GMC online license portal and the fourth schedule of the GMC Act 1971 does not have a provision for a trade license for a bed and breakfast establishment unit. As such, the petitioner had applied for a homestay license in terms of the GMC Act 1970, which was granted. However, due to the petitioners not having a trade license for homestay under the GMC Act 1971, the petitioners have been asked to close down the establishment.
the application of police verification. They have also stated it is a homestay. Because of homestay. In fact,
But then there is no trade license given for homestay.
homestay it will be kept trade license under the bylaw of 1976. That I have
Just be clear, madam. Guest house, homestay, what is because all of the acted.
No, Mr. Council, you have asked for homestay out there.
Madam, that is in fact also we can't to pay now 109 of the expedition. They own.
No, they have to, they will apply, but you tell them where to apply.
They have applied to the homestay. They have own document.
Bed and breakfast / homestay there.
That was before the license was granted by the certificate was granted by the. Because at the time.
This is 17th of 2021.
Then at the 1st of February 2022, the first AD license was granted.
Or 2022 was.
There's number 109 no,
No, but then you see, their bed and breakfast was in 2022. prior, after this letter.
But they have to get a license. Without license, they can open a business. It's a business. We will get the license, madam, but what is the tax against which? Whether it is a guest house, the tax is different. Whether it's a homestay, the tax is different. I'll do it. But you cannot shut down permanently the entire message. For one second, my lot will come to pay no wanted on that. If I is affidavit, I'll come up with a reply. That trade license they could put out online. That was done as a precautionary measure. And that also you have rejected. You said that's not valid.
Yes, 109.
109. Homestay, my lord, they have applied. 15 bedded homestay. Because bed and breakfast was not there. I have to do something. Bed and breakfast today is also not there. Well, let him say whether it's a guest house, I need a guest house license, whether I need a homestay license, I'll get it, man.
So he has to get what?
Homestay. So he's saying homestay.
So you apply for homestay license.
Well, that also, it was there at that point in time. Now also I have it. So if they say by the affidavit that a homestay license is required, I'll show in my reply that I have already possessed it, but I have to possess it.
Well,
If that you possess it, then
It's not here in the affidavit.
No, my lord, that particular, at page number 109, if you are looking at right now, that was there before the meeting.
Okay, anyway, let me find it. Right. That's right. The petitioners have been granted license to run a bread and breakfast establishment by the Ministry of Tourism, Government of India. And the same has been extended with effect from 6/6/24 to 5/6/2020. Next up. Mr. L. Bora, Learned Counsel for the respondent submitted. The petitioners would have to apply for a homestay license. Correct? Good, sir. He submits that as he has received instructions. He will file affidavit within a week. Leave the matter on next secure date.
At least till that, it will be a motion week, but
No, we'll do it. You have already fixed the date. We file it. Post up in the event. The respondents do not file any affidavit. Comma. The prayer for allowing the petitioner to run his bed and breakfast / homestay shall be considered as an interim measure on the link. Okay. So you can-
Later relates to the confiscation of the property of the petitioner. Under section 49. The section 49 of the forest regulation. And under 49C, appeal lies to the district. We have preferred
49,
C.
49B, who has to hear it?
49C, the district judge.
District judge has to hear it.
District judge to hear. Now, my lord, we have prepared the appeal before the district judge. The district judge has also, my lord, transferred it to the additional district judge, Vishwanath Aryan. Now the order, my lord, what it appears, my lord, it is in the order, my lord, the heading is for the additional section judge. And the finding by the additional section. It's the same authority, but so far as the additional section judge is concerned, my lord, he's exercising the power of the district judge. The district judge has, my lord, sent it to my lord, additional district. That is, it is not that we have prepared an appeal before the session judge. It is the order is transferred.
Okay.
So, madam, the leveling or the finding key, madam, this is not acceptable, but erroneously by the same person, he has done it. That may be one of the aspects. But this issue is no longer drawn into here because subsequently on 4/3/2023, the offense itself has been withdrawn. Now, the section 49 and section 59 of
It's just the government.
now the offense itself has been withdrawn on 4/3/2023.
What is the offense?
Offense under section 25/26 of the forest regulations. Where petitioner was never accused on that.
So once it is withdrawn, nothing remains.
Nothing remains. And the pattern of decisions of our court, in repetition as well as criminal repetition, the labeling, it has been categorically said that the confiscation under section 49(4) is temporary in measure. The actual confiscation will be under section 51 by the court. Now here, the offense itself has been withdrawn, where even I was not the made an accused there. So under section 57, when charges have been withdrawn and the proper,
Charges have been withdrawn against you only.
I was not the accused only. But I am the owner of the this Pockland. I had given
You're the owner of the,
Pockland, but the vehicle is question, my lord. One machinery excavation patch, my lord.
so you're not the owner.
I am the owner. I had given to my lord, 1% of my own itself footage to execute a my lord, the, road project. So while executing the road project, it had entered into the forest area of the Assam, reserve forest area of the Assam. So the vehicle was seized by them. Then thereafter this order of confiscation was made. Then offense report has been submitted against 2 other persons. Not the owner,
But this is your machinery.
my message. Now, the conviction can only be done when the owner has the knowledge. Now here, apparently, the finding of the confiscation order, it doesn't say that I had the knowledge, etc. But then, as I said, the reading of the section 49 and the 51, it would clearly appear that the confiscation under section 49 is a temporary measure till the offense is tried and convicted by the court, and thereafter order of confiscation to be passed by the court magistrate. And in case it ended in acquittal, in that case, under section 57, the forest officer has to release the vehicle when the charges have been withdrawn. So now, the moment this offense has been withdrawn on 4/3/2023
From all the accused.
from all, not first of all, offense report was not against me. 2 other persons, that also they have withdrawn. So the retention of the vehicle under the name of confiscation by the SCF is apparently illegal violative of article 19C as well as 308. This is my case. On that one, several decisions are there of this court.
Where is the withdrawal, the order withdrawal?
I have given separately, it is during the pendency of the petition. It is not there.
Huh?
This petition is not there. It is withdrawn subsequent to filing of this petition.
It could have always filed an additional affidavit.
That I, but it is in they themselves have withdrawn file. There is not be
This one,
clutching. It's the order of the court.
23.
Clutching. Petition is filed in 22 minutes.
Now it's 24.
20.
You had enough time to file.
We'll be doing.
He withdraws from prosecution in this case. He says she withdraws from prosecution.
50 minutes I have. So there is a government notification, the offences which are below 3 years, there's all offences were withdrawn from the.
Have you got this notification 21/10/22?
Madam, that is, which I recall, one of my senior counsel is probably wrong in that, madam. That notification speaks about those persons who are political members, madam. Who are political members, who are MLAs and party post holders, madam, portfolio holders, that offenses are good, madam. Which are punishable by 2 or 3 years.
I want to see this.
Yes.
I want to see this
Let
notification.
him think it. But this my case, visual done by them. I'll try my best to get the notification.
Only
but
thing, one thing is out here, you see, it says here. The court finds it fit to allow the petitioner in view of the provision of the. But nothing is clear from here.
From the learned assistant public prosecutor, Srimati Vinita Upadhyay has filed a petition bearing right petition number so under section 321 of JFPC, stating that as per SOP issued by notification number so, she withdraws
She withdraws from prosecution.
prosecution in this case.
She withdraws from prosecution.
A hardly learned provision on periodicity appears that the case is under section so, hence considering the fact and materials on record, this could find it fit to allow the petition number so in view of the provision of section 321 of JFPC, the petition number so hereby allowed and disposed of. The accused are hereby discharged. The bail bond so of the person shall be in court to next so. Let's this article be disposed of as per law in due course time. In concern,
You see, Mr. Counsel, this 321 is a prosecutor withdrawing from prosecuting the case. It is not a question of withdrawing the charges. It is
but the case is disposed of.
maybe, but you see that the issue is please read section 321. Please read 321. The public prosecutor or the APP in charge of a case may, with the consent of the court at any time before judgment is pronounced, withdraw from the prosecution of any person, either generally or in respect of one of the officers for which he is tried, reported in okay.
Any offenses? One or more of the offenses for which he is tried. An offense of withdrawal.
Okay, so they've all been withdrawn. This,
That has to come by affidavit. Otherwise, I was not only totally different footing of this case. This is a 226 matter, and they have come before surgery. Surgery prayers, my lord. The prayers, my lord, there has to be 2 basic ingredients, my lord, Surya the rice case, my lord. It's all missing here, madam.
Hmm?
Surya the rice case, my lord, where 226 of surgery, my lord, was, I was only totally different footing, and this was not in my knowledge, my lord, because it was not either filed by affidavit or either was filed by any additional affidavit by the petitioner, my lord, because this doesn't form part of the this application.
well, anyway, but
And
this,
therefore, well, these issues can be educated before the district judge. You know, what? Now, the section 57 itself says that district judge can very well allow my lord, adjudicate this on facts and give him the relief, my lord. Statute also says so. Otherwise, my lord, if I come to the other argument which is in forward, my lord, I am not the accused, my lord. My lord, I hold almost this kind of function, my lord. These are all owners, my lord. These are all owners who seek, my lord, who take the, the defense of ignorance that my driver did that, I didn't know anything. Recently, my lord, the Supreme Court again said, my lord.
no, I'm not on that. I'm not on that. That is not the
That is
issue
what-
now.
Well,
The
let
the-
them- my lord, let them-
The issue is this.
Let them,
The case, the prosecution has withdrawn from the charges.
well, let them
the charges made against
I
the.
have an instruction, if need to, but I'll bring the case report. But I was in a totally different footing, my lord. But was this maintainable?
The problem is you should have put in affidavit. Otherwise, we do not know. Because now it appears that there's nothing left in the case. Nothing. left.
Friday, my lord, very earlier, my lord. And
You can find this in the affidavit.
that's it, Friday, Friday, no. My lord, because if he finds, I have to take instruction, whether it is veracity has to be. Can he not take the instruction? This is the court's order, what I am producing before your.
No, otherwise, you see,
also,
if you had produced the certified copy, I could have taken note of. You also, you made a photocopy. You also have not been
On
fair.
date, my lord, you can
Huh?
take it. I'll submit it by way of application.
You give the certified copy end of the matter.
Yes, my lord.
You need a certified copy by district will dispose it of the register. There's nothing else.
Just let's take the time, my lord.
I look the previous cycle and taking it off and submit. That the truth is, the submit that the disposal of the appeal by the additional sections that should be read as disposal by the additional sections that the district. In support of its submission, it relies upon the order dated 11/11/2020 issued by the district judge. Sonnet Court, it missed bracket appeal case number 3 of 2020. Wherein it has been stated that the case is transferred to the court of the learned additional district judge, Vishwanath Charyali, Sonnet Court. Now another thing, this miscase 3 of 2020, whether it arises out of that main case or not, we do not know.
This fee is connected to the petition, and against that, they are before. Fee of 23.
Okay, it's 3 of 2020, okay,
It's
yeah.
57.
No, so that's what they say, yeah, no. So that's next, right. Further, as the case has been withdrawn against all the respondents, all the accused persons by the state power, there is nothing left to decide in this dispute. In support of the state, he has relied upon the order dated 4/3/23 passed by the JMFC, Vishwanath Charyal, in CR case number 59/23. The petitioner shall submit the above two orders, certified copy of the above two orders by way of an affidavit. Within
Okay, we,
the week, this is the matter. After the week,
okay. Interim of the first.
interim order for the week and 40 days later. After vacation or next week? When? It depends. I don't know. Certified copy is there.
After the vacation, let's.
This is the matter. Yes.
17 to that.
Okay. Yes.
Regarding what an outstanding bill of 4 lakh. File, I hasn't filed, madam. I hasn't filed.
I have forward.
Present
Okay.
income.
Right in the IA, right.
179.
Third, Mr.
A Borough.
Yes, A Borough.
I am filing A. I am
No, your name is A Borough.
A Borough, yeah.
A Borough, Learners Council for the applicant, / state petitioner. And Mr. S. Bora, Learners Council for the GMC,
Malo, BTC.
for the BTC.
BTC, Malo, that is for the response number, what's the contact number, that contact number.
Oh, for the response number, for the response. This application, this is an application for impeding Akash Deep, IAS. Principal Secretary, PTC Pokraja, F contemptor number 2. In as much as the respondent number 1 has been transferred or retired, what? Has been transferred out. Good, sir. Mr. S. Bora submits that he has got no objection to the application being allowed. So accordingly, the Akash Deep IAS, Principal Secretary, Borderland Territorial Council Pokraja, is included as respondent number 2. Applicants shall submit amended cost type to the registry within a week. That is the main case. Third with the A Boro and Mr. A Boro for the petition and Mr. S. Bora for the respondent number 1. In We have the order dated 18/6/2020, passed in ISC 1675 of 2020. CSID by Principal Secretary. ECC. Okada has been declared as a foreign law. Two. Issue notice returnable in 4 weeks to the respondent number 2. Petitioner takes steps for service of notice upon the respondent by the society within 3 days. This is the matter after full. Another one, I have been full. This is a bit difficult because the job was given to the employee back in 2013. So I didn't have a copy. I kept them the original one. Then this, now they are seeking a duplicate copy of one. Now I could recognize one thing as a copy to specify the thing that but it was issued from which bank? They said it was issued from the Indian bank. Now, if they give a copy of the FIR and the forwarding with that, when if they don't go to the bank, I'll go. I'll just verify if something is required. They can call down the bank and that much is it will further complicate them. Third, Mr. R. Singha, Learned Counsel for the petition. And Mr. N.J. Katania, Learned Counsel for the respondent number 3, for instance. The only issue left is with regard to non-payment of earnest money amounting to rupees 50,000. Mr. N.J. Katania, Learned Counsel for the response number 3, for instance, have submitted letter dated 15/6/2024 issued by the Director of Secretary Education, which is to the following. You take it from from 2 to the letter below that, right? The letter dated 15/6/2024 is made a part of the report and marked as an exhibit. Next para, Mr. R. Singha, Learned Counsel for the petitioner submit that he has had he has communicated with the bank and he has been informed that if the Directorate of Secretary Education submits an FIR to the concerned police station regarding the untraceability of the earnest money deposit of rupees 30 or 50,000. And a copy of the same is provided to the petition along with the forwarding letter. The petitioner will take up the matter with the bank, concerned bank. So, Mr. N.J. Katania submits that. The Directorate of Secretary Education can submit an FIR and give a copy of the same along with the forwarding copy to the petition. Correct? Correct. Within, I can do it by tomorrow itself. Sometime within a week, but within a week. Accordingly, leave this matter. Next week, give it.
Okay. Sir. Take your place. I'm very sorry, my lord. Totally blank, my lord. Like, my lord, I have certainly approached the board when they have proposed that one panel of arbitration. I said that I objected to it that I am not going to
Raise your right.
appoint one of the year panel. So thereafter, I also objected to waiver of 12 days. Thereafter, I approached to the court. And in pendency, after filing of this petition, they have appointed panel of one arbitration type. That panel is my lord. That is submitted by them.
No, earlier they did not appoint,
Earlier reviewed.
but they said they will appoint, but then you
appoint.
asked for your waiver,
Yes.
but you did not give.
Actually, my lord, they have given me one panel of their serving officer for appointing one of the officers from them. So I objected to this. They have given me one proposal to have at 12.5. I did not take it. Thereafter, I approached to this court by filing this petition. After filing of this petition, my lord, the railway has appointed arbitrators, a panel of arbitrators, one presiding officer and two arbitrators. They appointed. And that those arbitrators were appointed by the, I have objected against them that you cannot appoint. And now from here IA, it appears that the presiding officer as well as the arbitrators were appointed. Nobody was willing to proceed with the case, no matter, and even the presiding officer has also withdrawn.
No, that is not the.
That is another point. That
Where is the appointment of those
yes,
persons?
appointment, my lord.
Huh?
It is in page number, it is in page number 156
Of the writ petition,
of the
of the
affidavit officer.
arbitration petition,
Affidavit
156.
156.
Type.
Type code. Type code. Hello, General Manager, Malika has appointed.
So it is appointed two persons, not three,
Then he what?
My lord.
What?
My lord.
158.
It is clear.
Yes.
General Manager NF Railway Maligaon has appointed panel headed by three Pradeep Kumar, Executive Member, Infrastructure Railway Board, as presiding officer, and three Vijay Sharma, FNTAQ arbitrator. Three Sunil Mittal, arbitrator, decides that items of dispute out of contract agreement from process. The appointment, the two are serving officers of railway.
Then what happened to these arbitration? What happened? What did they say?
Then my lord, I have objected to it.
Then after that, you came to this court or what? That is during the pendency of the case.
They approach the court, is a pending.
So by that, actually, we approached the court before appointment of the judge.
Huh?
We approached court
Before the appointment of the
before
judge.
appointment.
But during the pendency of this case, they appointed.
Yeah. The case was filed, the case was filed on 25/9/23. 25/9/23, and they have appointed the arbitrator on 30/10/20.
That's all.
Yes.
Then so what is your stand?
Last time he said, they're going for the order type of. Because they are going to file everything.
These three are all your officers, correct?
Yes.
All railway officers.
All day.
So I have objected, my objection is also at page number 162. They have enacted my objection, page 1.
Pass the order. Yes.
Huh?
Alok has already passed the order. I can't keep that order.
But our chief is not railway officer. It's something else.
But here they all clear the data.
there is one case I did specifically on railway officer. I didn't have that.
Yes.
Have you got it?
That case number is madam.
Otherwise, also under section 12(5),
Article
Schedule 7, they
51
cannot
of
appoint.
2006.
51. Just give me 51 of 50. 23. That's right. That's it, right. That's not the thing. No. Let us wait for the order.
I don't.
Let us wait for the. So if we finish this case, I think we are free for the day. Or no?
Perhaps this is the last case. Sir.
So motion matters. There is a covered matter. This one. 51 of 2023.
Even of 20.
I will take it petition.
Party number.
The party name, forget. Party name is MS Barpita Agro Infra.
Perfect.
Barpita Agro Infra versus Union of India.
I will discuss, PPC, sub- that- that- with the-
11/3/2020. Exactly on this way. Where the railways had appointed their own arbitrators. Says here, when the general manager NF Railway himself cannot be made an arbitrator in view of section 12(5) and 7 schedule, the panel appointment of serving retired officials of the railways as arbitrators cannot be made by the said of. So the panel was set aside.
That is relying upon, I think, 2017 8 HC.
That is,
TRF Limited versus Energo Interface.
no, no, yeah. It is relying upon 2020, 14 and 7,
Right.
not 2017, sorry. 2017 is CRS.
TRF. TRF. That is also on similar line. Sir. Regarding any breach of permission.
So this 2020 judgment is in favor of them.
Right.
Central Organization for Railway Electricity. That is in favor.
Attached
But TRF Limited
TRP is again.
and Perkins Eastman is in your favor.
Then the matter is pending before Supreme Court regarding
Ah.
Tata Customs.
So this matter is pending before the Supreme
Yes,
Court
yeah.
now. But Supreme Court then passed a judgment in Union Territory, Ladakh, was Jammu and Kashmir also, held that when faced with conflicting decisions by benches of equal strength of the Supreme Court, the earlier judgment has to be followed by the High Court. So that is why, following the earlier judgment in TRF and Eastman Perkins, then
Otherwise, also there is no doubt regarding Supreme Court. Also, there is no doubt that serving railway officer cannot wait for.
no.
This is regarding retired
No.
railway. The dispute is regarding
Central Organization for Railway Electricity, the three judges bench of the Supreme Court held that when a contract agreement specifically provides for appointment of an arbitral tribunal consisting of three arbitrators from out of the panel of serving or retired railway officers.
all retired. That is
Serving or retired, so both you can.
all retired.
The appointment of the arbitrator should be done in terms of the agreement as agreed by the party. So this is in complete variance with the earlier judge. Okay. Okay, right. What have I said? Oh, third, Mr.
SJ Samra.
S. J. Sharma, Learned Counsel for the petitioner. Also heard Ms. A. Gan, Learned CG. Then order dated 7/2/2024, huh? Para 2. Para 3. Para 4. Huh? The petitioner counsel submit that due to a dispute between the parties, the railways, the respondent railways, wrote a letter to the petitioner stating that an arbitral tribunal was to be constituted in terms of clause 64, bracket 3, bracket A, bracket 2. Correct? Bracket. Page, fill that page.
Page 129. Before bracket C, bracket A, bracket C.
Page 129. Huh? Which states has followed? Which states has followed? Page 129. Next up, the petitioner's counsel submits that the petitioner had been requested to waive his right and the section 12(5) of the Act. So as to enable the respondent to appoint three serving/retired railway officers to prosecute the arbitral tribunal. The petitioner refused to waive his right under section 12(5) of the Act, and instead filed the present petition for appointment of an arbitrator. So, next up, the petitioner's counsel subject that subsequent to the filing of the petition, the respondent constituted an arbitral tribunal consisting of three retired or serving.
My lord, general magistrate,
No, this
headed by Sri Pratikon as executive member, ex-member.
they retired or serving.
One retired and two serving.
Okay, so they are of serving and retired railway officers to decide the dispute between the parties. Right, letter dated
30/10/26.
Huh?
30/10/26.
page,
Page 158, my lord. It is affidavit in opposition.
five letters dated, 30/10/23. What a method. Not to waive the right section 5, what a method. No, before that, before that. Yes. Next. This spot, on hearing the parties by order dated 10/4/24, has held that as the petitioner had a right not to concede to the waiver of section 12(5) of the Act, in keeping in view the requirements of section 12(5) and schedule 7 of the Act, propose an arbitral tribunal to consist of the Honorable Justice, Mr. Justice C.R. Sharma, as the chairman as the chairman of the arbitral tribunal, with Mr. Mrinmoy Kumar Bhattacharjee and Shri Pradeep Kumar Das, who are both retired district and session judges. The registry was also directed to make communication with the members of the arbitral tribunal, seeking disclosure as provided under subsection 8 of section 11 of the Act. Consequent to the order dated 10/4/2020, reports have been made to the effect that the proposed arbitrators were willing to take up the dispute, to take up the case, to take up the dispute between the parties as an arbitral tribunal. Correct? It could have been disposed of. Anyway, right. Next up, Miss Kagan, current CCC topic. That the arbitration clause provided in the contract agreement between the parties provides for an arbitral tribunal made up of retired serving railway officers and the petitioner was to suggest two names from among the list of four names that had been set. So, however, the petitioner had not suggested any name for appointment of an arbitration. However, as the arbitration clause provided, the manner in which the arbitration council was to be constituted of the railways, the respondent railways had appointed the arbitral tribunal in terms of the arbitration clause provided in the contract agreement by letter dated 30/10/2020. The learned feedback the learned feedback he submit that the proposal made by this court cannot be accepted in as much as the arbitration as much as the same is not in consonance with the arbitral tribunal. In the alternative, which again then CPC topic, that even if an arbitral tribunal is to be constituted, the same to consist of only one arbitrator. Correct?
Yes.
I have heard on that now. So the question to be decided is as to whether the respondent railway could have appointed serving retired railway officers as arbitrators in the absence of any waiver given by the petitioner under section 12(5) of the Act. In the case of Perkins Eastman Architects DPC and another versus HSTC India Limited reported in 2020 20 SC 76. The Supreme Court has held that any person who falls under any of the categories specified in the seventh schedule shall be ineligible to be appointed as an arbitrator. Further, a person who is statutorily ineligible to be an arbitrator cannot nominate a person as an arbitrator. In this out here, para 16 in this arbitration section 51 of it. Then In the case of TRF, in the case of TRF Limited versus Energo Engineering Private Engineering Projects Limited, reported in 2017, 8 FCC 377. The Supreme Court held that by virtue of Section 12, bracket 5 of the 1990 Act, if any person who falls under any of the categories specified in the seventh schedule, shall be ineligible to be appointed as an arbitrator, by operation of law. Secondly, a person ineligible to become an operator, arbitrator, cannot nominate another as an arbitrator. Para 30. In view of, in PRF Limited, in view of the judgments of this, in view of the two judgments of the Supreme Court, stated above, comma, stated above, no, not comma, and the fact that the application for appointment for an arbitrator has been made subsequent to the amendment of Section 12 of the 1996 Act, of the Act, comma. This court is of the view that the respondent railway could not nominate arbitrators from among its own serving retired officers, to decide the dispute between the parties. Next para. Having stated the above, in the case of, having stated above, another three judges bench of the Supreme Court held a different view in Central Organization for Railway Electrification versus MSPCI-SPIC-SMO-MCML bracket JV, a joint venture company, reported in 2020 14 SPC 71. That you right? Next para, right? Para 18. Para 18 you see. Next para 19 you see. Next para 20 you see. Para 21. Next para. In the case of MS Barpita Agro Infra versus the Union of India and two others, arbitration petition 51/2020, this court was to decide the question with regard whether the making of a panel / appointment of members of the arbitral tribunal by the railway was hit by Section 12 bracket 5 and section and the 7th schedule of the Act. this spot, next para, this spot, then you take this spot, then para 23 you take, huh? No, don't say this spot, you just take para 23 next para, huh? Next para, if you have the real state above, it is clear that the respondent railway would not have constituted an arbitral tribunal consisting of serving and retired railway officers. As it was not in consonance with section 12, bracket 5 and 7, as the 7th schedule of the Act. So, in view of the reasons stated above, the arbitral tribunal constituted by the railways in terms of the letter dated 30/11/23. Letters dated 30/11/23. Huh?
30/10/20.
30,
10.
10, 23 are hereby settled. As the respondent, alternative prayer is for appointment of a single arbitration. This court appoints Justice. Since Justice Sharma had already been proposed earlier, by the is already Justice K.R. Sharma, retired judge of this court, is appointed arbitrator to decide the dispute between the parties. The party shall appear before the learned arbitrator within a period of 1 month. 1 month. 1 month from today. The uh, the the disclosures required from the arbitrator in terms of the amended section 12(1). Arbitration Act 5. 5 and the 7 schedule.
8.
Huh?
Till 8.
Or 11, huh? 11(5) what? 12(5). This is the old one.
11/8, my lord.
Very thin. The new one is slightly thicker.
It's an 11/8. My lord.
This has already been taken, I think.
It's already taken. It has already come.
What have I said? No, I'm under the amended section. It's in terms of section 11(8), having already been taken from Justice K.R. Sharma, retired Justice K.R. Sharma. We have already been taken from Justice K.R. That's all. The arbitration is accordingly disposed of. Okay, I have to set, I have already set aside. Okay. Then you write in view of the disposal of the main arbitration petition, CI is also accordingly disposed. I put it here. It's the main thing. Oh, you preview. I put it-
My lord, the issue involved this matter with my lord. The petitioner was an employee workman under the response number 2 private company. In 1990, he was dismissed from service.
1990 dismissed from service.
He dismissed from. So the matter was referred to the invested tribunal. The invested tribunal by award has set aside the order of dismissal and passed order also for equities, reinstatement and equity. Now, I have received equity, but the calculation they have made in 1989, when my service was confirmed as junior operator, on that day, that 390 rupees per month, along with such allowances, that was calculated till 2014 when the reinstatement was paid. This is the
No, what is the issue?
issue is about the back wages.
Back wages, yes.
Back wages. Back wages. 2014, the award was passed. 2013, the award was passed. 2000, my lord, exact date I can give notice, my lord. 11/2/2013, award was passed
Award was passed by the tribunal.
by the table. Setting aside my dismissal order and also reinstatement and back wage,
When were you dismissed from service?
my lord,
When were you dismissed from service?
1990,
Where?
18/4/1990.
For what? For what? What
My
was
lord,
the,
yes, the reason was, my lord, the vehicle, I took the vehicle with the permission and some money over time I worked and the bill I have given to work, my lord. So London tribunal not satisfied with that, my lord. Nobody has given the evidence from the opposite side, my lord. Termination orders were not given to me, all these things, my lord. So it was set aside by the tribunal and order for
so your back wages from 1989, which month?
19, from the dismissed from 18/4/1990. So from the dismissal order, till reinstatement, they have calculated
18 for 1990
Yes.
dismissed.
and the reinstatement order was, my lord, of 33/2014. 30, 33,
2014.
14, my lord, the reinstatement order. Now, the issue from my side is, my lord, when they calculated the back wages, they have taken the figure which I was receiving in 1990. They have multiplied into 12 months and, my lord, for 14 years, my lord. That was. Now, my contention will be, my lord,
As per rate of 1990.
1990.
So what is wrong?
But there is a revision. Lordship,
Okay.
kindly see your lordship, my lord, 2 orders dated, my lord, in the file, lordship, kindly
So
see
in
the-
1990, how much were you getting?
my lord, that is the calculation now. That is the calculation they shall to make. And the lordship see the order, my lord, lordship, in the file, my lord. The order is on 17/3/2017. That's 2 orders. I just refer.
Page,
My lord, that's in the file, lordship file, my 17/3/2017.
what are order?
Yes, production.
17, 3,
17.
yes.
But second paragraph, can you see? The case of the petitioner is that pursuant to the order dated 11/2/13 passed by the industry tribunal in reference case number such and such, the petitioner was accorded relief with direction to the respondent two to reinstatement the petitioner with effect from 18/4/90 and to accord full back wages on such reinstatement. The petitioner is agreed by the calculation made by the respondent two by taking the basic pay of 390 without any consideration about the subsequent revision that has taken place since 1990. At this stage, notice that in the last paragraph, respondent one on the next returnable date shall furnish a revision that has been made to the basic pay 390 since the year 1990, along with other administrative allowances attached to the salary. And this is the next to order, my lord, 17/5/18. 17/5/18 order sheet.
17, 5, 18.
Yes. Got it, my lord? 17/5/18. Last 2 para.
Yes.
By order dated 17/17, this court had directed the respondent one to furnish the revision that has been made to the basic pay of 390 since the year 1990, along with other admissible allowances attached to the salary in the form of affidavit. In other words, 17,317, respondent 1 has been wrongly typed, which should be respondent 2 should be my lord. Pardon, sir. Mr. Bora ensures that by the next available date, the respondent 2 shall file affidavit furnishing the revision that has been made to the basic pay of the 1990, my lord. So that is the calculation they have made, taking figure of the 1990, my lord. Now they have submitted their affidavit. In the affidavit was filed on 19/6/18 on the basis of the order passed by last
Affidavit, where
19/6/18, the respondent has filed the affidavit.
1906. I have got 1/7 May.
It is still active. It's an additional affidavit, yes.
Okay, additional affidavit. Yes.
Yes. Here, my lord. Paragraph, page number 2,
Page 2, yes.
paragraph 2. In terms of the order dated 17/3/17 and 17/5/18, the honorable court has directed the respondent 2 to file the present additional affidavit to furnish such and such. My representative 3, the respondent 2 humbly begs to state that in such which revision, salary increment are purely depending on the following factors, namely: A, annual performance appraisal; B, fixed step training program; C, overall performance. Now A, this Schlumberger appraisal process, employee has to record his specific and measurable objects in the appraisal system. So since the petitioner was out of service, my lord, he has not done that. So that stick to their, my lord, salary active. Now, I will rely on the judgments of the court on this equity system. Those judgments and losses fine. My lord, that in 1999, 4 essays. 1999, 4 essays. Party's name State Bank of India versus TJ4. On top, I think, my lord, and has been. Worship, kindly come to paragraph number 20, my lord. Paragraph number 20. This is also a bank employee, my lord. He was, my lord, dismissed and then removed from service, but honorable apex court in the paragraph 20, in the reserve, paragraph 20, last year. In the result, the setting aside of the order of removal is done by the High Court is sustained. The direction to pay him back wage, grant such promotion and monetary benefit by your salary, promotion, increment, etc., as the High Court will remain, my lord. So there, my lord, that back wages, monetary benefit, promotion, increment, etc., granted, my lord. There will, however, be modification of the order of the single judge. So the division bench to extend, namely, the matter will go back to the appellate authority for considering which of the punishment such and such, my lord. Dismissal without notice. The benefit above referred to as directed by the High Court shall compute and paid such and such, my lord. This is one lordship is my lord. Now the next one is of Gammon India. It's a 1984 one.
What do you want to show?
I want to show, my lord, kindly see about the back wages part. Back wages, kindly, what it includes? Back wages includes, kindly see, back wages such as promotion, monetary benefit, by way of salary, promotion, increment. I want to show increment. These are the things included. One lordship, they directed, there's a direction for back wages. Back wages doesn't mean only that monthly salary. It also increases promotional prospect, then what will be the salary, monetary benefits, by way of salary, promotion, increment. This is also include promotion, my lord. Now, kindly see the second case, my lord. This of Gammon India, that's a 1984 one assessment. 1984 one assessment, page 509. Lordship, we come to the paragraph 4, last paragraph, last page.
Yes.
case. Let me read that. That's an important part. There are Lordship got paragraph 4. In the course of hearing of this appeal, it was stated that the respondent has reached the age of superannuation, therefore physical enlistment in service is not possible. Appellant will have to establish the fact, but in the event appellant shows that under a valid rule, respondent has reached the age of superannuation and therefore physical enlistment is not possible. It is hereby declared that respondent shall continue to be in service uninterruptedly from the date of attempted termination of service to the date of superannuation. This is next line in my term. Respondent would be entitled to all back wages, including the benefit of revised wages, salary, if during the period there is a revision of pay scales with yearly increment, revised yearly allowances or variable yearly allowances, and all terminated benefits if he has reached the age of superannuation and provident fund. Back wages should be calculated as if the respondent continued in service uninterrupted. That's my case. Had it not been, my lord, even dismissed from service, he would have continued, my lord. And when he continued, this is what it is. Assuming he's in service, he'll get promotion, next promotion, and then increment, my lord. The chronologically it goes up, my lord. That shall have calculated. This will submission. Now there's one judgment of the losses, my lord. Imranullah. I think we'll close.
Okay, 2 o'clock.
Right.
How long will you take?
My lord, actually, this is the basic contention. But factually, my lord, once I know that to go, then I have to place the fact from the theory, my
What fact?
of this fact, but I don't think it's it depends on my lord, my lord. What?
What fact? These are the facts.
Some additional factors. Actually, the scope of this expectation is whether under section 33C, whether it is an execution proceeding or where you which can be discussed. Because he is against an order passed on his claim before the tribunal was rejected. Now that all he is claiming, this was rejected by the tribunal, against that he is before.
Execution is allowed.
No,
First
second time there is another word. He is before your lordship,
That
excelling the order of the industrial tribunal, where his claim for increment and outward.
So basic confusion I think. Now it is the fact, my lord. So
It will take time.
it will take time. Yes.
I don't know, it depends upon your. That stuff is from that side. It depends upon it.
It's all right, my lord. If it time permits, we'll do. Otherwise, there's not then both of us absolutely free from what this side.
Yeah, this. Any observations or findings that may have been made by the court with regard to the merits of the case should not be considered to be the final findings or observations with regard to the merits of the case, as only the maintainability of the writ petition has been decided. The writ petition is accordingly decided. It also is dismissed. Dismissed. Right, sir.
My lord. Let him please the fact, my lord. Because
How long will it take? How long will you take?
I think half an hour.
Are you sure?
I'll try, my lord. But if I read also, maybe little longer also. And they will take also.
How many citations are you going to give me?
No, citation is another 1 and 2. Your lordship judgment is there, my lord, about Bekovic. This is what I have pointed out is the legal point, my. That's what. But actually, I place my lord. Ultimately, lordship will find after everything, my lord, will come to this point. That's why I say the issue involved with this. Now, just what happened? Can I place my lord? Or shall I? My lord, I was dismissed from service in 1990. So, matter referred to the industry tribunal. Tribunal has passed the award.
What was the award? Upholding the dismissal.
No, that award is, my lord, for instant setting aside the dismissal order, reinstatement with back wages. Against
Just a
that,
minute. The arbitral award dated, award
11,
dated
11 to 2013.
award 11 to.
Arbitral award.
Huh?
Arbitral award.
I'm sorry.
First award.
It's by the labor court.
No,
Labor
I'm
court.
coming to that.
This is that.
Yes.
Page
Page 21 to 42.
11 to 2013.
To 30.
Page 14, 42.
Page 21 to 42.
My God. 21 to 42.
Yes.
So the final decision was that
Reinstatement
statement,
with back wages.
that's all.
Yes, my lord. On 30/3/2014, they gave me a letter of employment. After the judgment, award.
11?
That's on 30/30.
No.
30th of March 14.
That is the part.
Yes.
Letter of employment.
Yes. Now, what they've done here, when I was dismissed from service, I was in grade 3. The lordship will find in the document is there. When they reinstated me, they reinstated me in grade 2. And it's just the fact.
So promotion.
No, not promotion, demotion.
Promotion. At a grade 3 is,
Yes, it goes upward. 2 to 3.
so it goes 2 to 3. So
Yeah,
if you're 20, so you're very high.
They have got down.
So you go from grade 1 to
Any-
20.
And my lord, it's just a fact. Next, my lord, when they gave me this letter to join, they gave me to join in Bombay. But when I was dismissed, I was in Silchar, my lord. So I wrote to them, please do one thing, you allow me to join in Nazira because they've got a branch in Nazira. It's a drilling company, my lord. They drill it for the well, my lord.
For this 4, 3, 4 well drilling.
Yes.
4 well drilling.
It's a huge company. No,
It's for water.
no, not water. Well.
Oil.
It's a huge Canadian company.
When
It's
you
a-
said, okay, I thought you said well. WELL.
It's a giant Canadian company. Not the worldly function. Now, my lord, when I went to Bombay, ultimately, lot of communication. I said, allow me to join in Najira. So they said, no, not in Najira, you have to come to Bombay. So there was a lot of communications. Ultimately, I went to Bombay, went 12/5/2014.
12/5/2014, you went to Bombay.
I went to Bombay.
Ah.
There are certain things that happened. I went to the office, they made me speak for whole day. Then they gave me a check of rupees 4 lakh, calculating 390 per month. They gave me a check of 4,57,000, something like
390 per month, fixed pay.
fixed pay and certain allowances. So they calculated 12 months into 14 years. So it comes to 4,51,000. That's what happened, my God. When I went from Silchar to Bombay, Gossipin, imagine, at a giant company, but went to the office, that is a huge problem. I was almost assaulted by those group of, my Lord, Tata, they are employees and all. Ultimately, I had to run away from Bombay. I came back to Silchar. I filed an FIR.
Assaulted.
FIR.
Why didn't you file FIR there in Bombay?
Yeah, to wait. I was running for my life because when I went to the office, my was a huge problem. I was around by those persons. You imagine, my lord, that company went from that place to went to Bombay and what happened, my lord, almost. That's the threat of his life. So he had to come back to Silchar. He filed the FIR. The police, what they have done, they sent his FIR to Bombay.
Actually, the
Obviously.
jurisdiction is Bombay.
Thereafter, my lord, spending that year, my lord, don't know exactly what happened. Subsequently, I filed a petition before the Assistant Labour Commission that according to my calculation,
my entire wages comes to 2 crores something. For 14 years, something like that. So still labor commissioner,
From 4 lakhs to 2 crores.
2 crores it pays. So still labor commissioner issued a certificate,
Who issued certificate?
assistant labor commissioner, because there is no labor code in future. So still labor commissioner passed an order, give a certificate about this 2 crores. Against that order, my lord, my learned friends complained, they had a writ petition. In that writ petition, that my lord, the order was passed by the honorable court on 13
Yes.
Two-
Let us see the assistant labor commissioner's order.
order, that's page 62, page 61. Page 60. Type portion is in page number 58. Type part is my page 58. Can I read this, my?
Court, it is court.
This is a court of assistant labor commissioner, section. Basically, it's a labor commission.
Yes.
Let me read this part, page 50. Can I read my?
Yes, yes.
Since the petition filed by the Vibhushan Dev petitioner under section 33C of Industrial Dispute Act, also seen the supporting documents, award, element notification, employer's offer letter, other connected documents. The petitioner workman has contended that the opposite party employer has not paid his wages amounting to 2 crore 26 lakh. His conclusion is that as per industrial frequency award dated 11 to 13, the OP employer asked the petitioner to report to Mumbai office of the OP employer. And according to the petitioner joined on 12/5/14. According to the letter, the total wages of the petitioner from 1/1/90 to 34/14 stands as rupees 2 crore 31 lakh, out of which he has been received employer to the sum of rupees 4 lakh 75,000. And as such, there is a shortfall of rupees 2 lakh 23,000. So 22 lakhs, 2 crore 26 lakh, which is yet to be paid with the employer. The details of the unpaid wages are elaborated given in the petition. The last payment made by the OP on 2/5/14 in Bombay, and as such claim is within limited. On perusal of the petition and the document, I am satisfied that the money as claimed by the workman is so due, which is required to be realized from the employer by your packaging process. Hence, a requisition for certificate may be issued such as my lord. Come to the next page, my lord, and thereafter, a certificate has been page 62. Certificate, the main part is in page number 63 and 60. That's about 2 crores, my lord. This has been challenged by my learned friend company, my lord. It's one number 2. And the judgment passed by the honorable court is page number 64. That's it. How we are before this court? From here, lord, to get it. Page 64. Page 64, my lord. 13/2/2015.
Ah.
Paragraph.
Paragraph 2.
Yes, page 67. This writ petition is filed assailing the notices dated G12/14 and except 3 issued by the respondent 2 and to quash the proceeding in Bakije case number initiated on the basis of the said notice for recovery of 2 crore. In view of the
Wait a minute, where is this 3/12/14?
my lord, these certificates, that amount, this part, my lord.
No, it says a failing notice stated 3/12/14. Where is this 3/12/14?
My lord, 3/12 notice is not here, but regarding this proceeding, my lord, the Bakije case.
Page?
62 is
62 is 410,
1410, yes.
1410.
Certificate 24. This is about
No,
this,
no, that's all, but that 3/12 is not here.
not here, but this is about my packaging clean, my lord, that's one. Ultimately, my lord, para 3. In view of the consensus arrived at, a detailed narration of facts may not be necessary. Para 4, the 3.
Sufficient to say that respondent 4 was a workman under the petitioner. Respondent 4 was dismissed from service on 18/4/1990, and a dispute having arisen, the government of Assam referred the dispute for adjudication under Section 10 of the IT Act. For short, whether on the following issue, whether management signature is justified in dismissing the Bibu Debrai from service with effect from 18/4/90, whether the workman is entitled for reinstatement with back wages. All other relief, therefore, the said reference of registered service as follows. Because of what has been discussed as above, I hold that the management MS Kumar Service Limited is not justified in dismissing the workman Debrai from service with effect from 18/4/1990. And is entitled for reinstatement in the establishment of the management with full back wages. In this way, both the issues are answered. In such circumstances, the management of Kumar Asia Limited is hereby directed to reinstate the petitioner workman, no workman, see Bibu Debra immediately in the same post if such post is not abolished and if such post was already abolished in a post of same rank and responsibility and to pay him the full back wages within 3 months. Thus, the workman was entitled for reinstatement as the workman in the same post if such post was not abolished and if such post was already abolished in a post of same rank. It is contended by the management that management offered re-employment to the workman and also back wages to the tune of 4,50,000, which is accepted by the workman towards back wages without any protest. In Bombay, I made oral protest. Verified. They submitted that it is not the respondent of who had accepted the amount without any protest. For survival, the workman had to accept whatever was offered to him by way of back wages, and thereafter, he immediately raised a dispute before the Labor Commission Secretary by filing the application, which was registered number 32. The Lana State Labor Commissioner Secretary passed an order dated 14/10/14 holding that there is shortfall of rupees 2 crores 26 lakhs on account of back wages, taking note of the fact that some of rupees certain sources paid. Impugn notices which are already referred to imprinted from the education of the Labor Commission Secretary. At this stage, it may be noted that it is admitted position that in the said adjudication process, the petitioner was not associated. The writ petition of the company. Mr. Day has also submitted that now the petitioner has questioned the adjudication made by the Labor Commissioner Silchar for your initiation of the proceeding before this court. It will be only proper for the responsible workman to approach the landed labor court at Qatar Silchar under section 33C2 of the Act for determination of the amount which the responsible is entitled to as back wages under award dated even to 13. Mr. They have fair enough candidly accept that logical fallout of his submission would be that notices dated C12/14 by the recovery officer as well as certificate issued by the State Labor Commissioner Kacha Silchar have to be set aside and the Pakije case number such would necessarily have to be closed and disposed of. Mr. Bora Lane Council respondent does not oppose the submission of Mr. Day and submit that in view of the said submission, presently no issue suffices to consider it. In view of the agreement of the Land Council for the parties, without expressing any opinion on merits in subject matter of the dispute, the impugn notices dated T12/14 issued by the recovery officer, certificate dated 39/14 issued by State Labor Commissioner, Silchar Bakije case are set aside required. Now the important part, para 14. Respondent 4 in with submission of Mr. Day is not opposed to Mr. Bora may file appropriate application before the Landed Labor Court Kacha Silchar under section 33C2 of the Act of 1947. Mr. They submit their within a period of 15 days from the date he will file such and such minor. There are both the councils submit that in view of the long pendency of this case, the parties will appear before the Landed Labor Court Kacha Silchar on 31/3/15 to take up the matter. Accordingly, in view of the submissions, it is provided that petitioner and the rest of 4 will appear before the Landed Labor Court Kacha Silchar on 31/3/15 minor. Actually, since there was no labor court in my lord Silchar, so the petitioners filed before the number of now, Lordship will find the award was passed by that labor court, my lord. This in page number 72, my lord. This is the understanding this court. my lord. It seems to be pretty long. I'll take the losses to the main part, my lord. I'll take the losses. Can I take a losses to the right of my lord in page 78 from there? Or my lord, page 74. 73 also is important, my lord. Can I take long the same thing? How to talk? The crux of the matter is, my lord, here. That calculation, 390. So you kindly see that calculation. I think it will be easier, my lord. That's in page number 82.
Very important. Oh, they're feeling well.
Expect painful and bit steep, my lord. My lord. This is
Yes,
now this judgment, the class of the judgment thing. Please come to page 82. What has happened? That calculation, 390 rupees. The landed court, my lord, labor court insisted and relied on this, my lord, and passed the judgment. Our claim was more. Page 82, kindly see the calculation, their calculation. Page 82, wage component. Lordship is wage component, page 82. Kindly see basic 390, DA 312, HRA 550, feed allowance is 331, total per month 1581. Now, Lordship, kindly see my page 19, that figure when my service was confirmed, page number 19, this figure, Lordship, will get it.
yes, where is the, so there is no income tax. You're not liable to income tax.
My lord,
Are you liable to income tax?
no, nothing, no.
Are you sure?
Workmen, no, they don't get.
Huh?
Workmen, my lord, how much they get? 390 per month. That time 1990, there's nothing about income tax. So this calculation, my lord, lordship can find page number 82. In page number, my lord, please come to page number 19. See my confirmation order,
90.
page 19. The lordship will see that it will tell you in 1989 order was passed or 87, but page 19. Page 19, confirmation to junior operator, grade 3. First subject, kindly see subject. Lordship is in my lord, subject. Page 19, top third line. To be
Yes,
to the,
yes,
yes. Confirmation to junior operator, grade 3. In grade 3, I was confirmed. Bottom and middle, basic salary 370. Dear DA 296. Housing 450. And now, Lordship, kindly see the page 80, 82. Here comes 390. Confirmation order, that one. The 390. Now, if your Lordship come to another comparison, please come to page number 105. Salary slip, my salary slip in 1989, December. 105 page number. And Lordship hold the page 82 also. Lordship, 105 page number.
105.
Yes.
Yes,
My basic salary 390, Lordship is seen. Can you see?
yes, yes.
Now compare with page 82. Same thing. By this, I am trying to show to your Lordship. Whatever I was receiving in December 1989, same thing they have calculated in 2014. And this was calculated page 82, kindly see, therefore. Page 82 now, kindly see calculation. After serial number 4, 1, 2, 3, 4, serial number. But therefore,
But they're giving you overtime. How can they give you overtime?
That's why overtime is there, and not only overtime, even there's increment also. I'll come to the overtime, my lord. Now, lordship is in the judgment. Had I, they kept me in the service. Whatever chronologically could have come, that salary, my lord, salary 2019, the 1940 is not a salary. In 2014, that salary 2019 is not there. Then the promotional scope is also there. That part they still have to take into consideration as part of the judgment of the FS Court. FS Court is clearly stated. So, the learned labor court, my lord, came to the finding, which finding lordship may kind of page number 83. Please come. From there I'll read. Page 83. My lord, I'm just asking. Shall we continue?
I don't know.
No, I'm saying the lordship is
How long will you take?
because the
More on that.
at least to place the fact, I think will take some time. That's what I'm saying.
That's why I asked you in the very beginning. How long? You said half an hour.
And-
Another 5 minutes left for you only.
Another 5 minutes, my lord. I think 5 to 10 minutes, I think I'll complete. Because I'll show this judgment. Then the question, my lord, what will be salary? This is the crux of the matter. Now, this is under challenge before the court. So findings of this tribunal, my lord, please come to 83. Let me read this part and then we'll go to the petition. Page 83. In the middle, I'm saying, in the middle, in the cross-examination, page 83. There, in the labor court, the management witnesses, my lord, report. In his cross-examination, he has stated that he is the human resource representative of opposite party, my lord, that's number 2. He deals with the joining till retirement of the employee serving in the company. He is aware about the fact that claimant was wrongfully terminated. And he had successfully won a case reinstatement of industrial criminal Silchar. He was not in the company when termination of the claimant took place.
Look, whether these things are important, your only issue is with regard to the pay.
Beginning, I said that's the reason. Because other side might say that I had suppressed the tax. That's the reason I think. Otherwise, my lord, this is what operative part kindly see, my lord. Operative part page 84. Lordship kindly come. That 84. Lordship is understood, my lord, what I'm trying to say exactly. 84 at Para 11. Learned labor court while passing the award has made it clear that page 84 bottom. That petitioner is entitled for reinstatement with full back wages from the date of dismissal. However, there is no specific direction as regards notional increment of the petitioner. In absence of such specific direction, the requirement of law is that executing court cannot determine increment notionally. In such circumstances, it is not entitled for increment from the claim petition as well as evidence of record. The admitted position is that petitioner has already received an amount of 4,50,000 as back wages. Said back wages were paid by the manager as follows. That calculation. Page 84A. 1583, 1,580 into 23 years and 8 months. It comes to 4 lakh. The computation made by management is in accordance with the pay slip issued to the petitioner and the same is acceptable in view of the fact. From the above discussion, I am of the view that there is no merit in the petition to dismiss it without cost. That is under my lord challenge in this petition. That this judgment is under challenge in this petition by the people, the workmen. Now the basic contention is, my lord, we go back to the
Where is that earlier one, that earlier pay you had at the beginning when you were dismissed?
My lord, your lordship may kindly say that the
370, wait, so 370
page 70.
per month.
Oh, yes. Just give me a 105, page number 105, can you see?
No, 105 is the calculation they made
Calculation sheet, yes.
after, no, before that.
Page number
15.
19, page number 19, my
Yes.
confirmation order, page 19, 19. And last page is was page 105.
109.
105, last page. Now, Lordship has seen from the judgments, my lord. Shall I take the judgments now? Because that's the point only to be decided by your lordship. Last two one, I reiterate the paragraph once again, my lord. That part, that intimate goes up and other things, my lord. That part, lordship will find in Gammon India case. Gammon India case, 1984 1 essay. Paragraph 4, lordship is noted. But once again, I'm stressed on that.
No, this is what, this is, are you working for the, are you a government servant?
No, I'm
You're
not.
a workman
Workman.
in
He's also bank employee, my lord. Workman, my lord. This is the way it goes, my lord.
so they'll be having their own pay revision or whatever. They don't go by
But
the
the
government.
principle is, principle, what is the principle, my lord? Kindly see this is,
No, but you have
this is
got-
also under industrial tribunal, my lord.
no, you have got to show what revision of pay there was during the time.
I
between
was
the-
terminated from service in 1990, dismissed. Subsequently, my lord, what will be the revision, my lord? They can say that's the reason lordship has passed the
Oh,
order, my
so,
lord.
so you don't know what the revision is?
No, that's the reason lordship has passed the order on 17,580. It's the reason. For what? What revision of senior employees took place? Then I will be entitled, my lord. You know, in one, my lord, workman will get it, my lord. Kindly see the order dated, my lord, 17,5. This court has directed the respondent one to furnish 17,580, 18, 17,5.
Yes.
By the order dated 17, this court has directed the respondent number one to furnish the revision that has made to the basic pay of G90, which is the year 1990, along with other administrative allowances attached towards the salary in the form of affidavit.
Okay, if they say there was no revision of pay, then end of
How
the matter.
can it possible, my lord? A man's salary gets in 1990 will get into 1990.
I don't know. You tell me. Since you don't know, if they say if there was no revision, then what happened?
No, they have not said so. They say what? They say since this man was not in the working period, there are certain stages, that's why it was not done. Assuming the Supreme Court says, my lord, that's why it's there's that case, my lord. It is. Respondent would be para 4 of that Gammon India case.
Huh?
Gammon India case, 1984 1, I think. See once again, my lord,
Yes.
the language here.
Yes.
Respondent would be entitled to all back wages, including the benefit of revised wages of salary, if during the period there is a revision of pay scales with yearly increment, revised DNS allowances or variable DNS allowances, and all terminal benefits as if he reached the age of supervision. Back wages should be calculated as if the respondent continued in service in uninterrupted. Now, had I not been dismissed, I would have continued to 2014. No, fairly they should come and say that, yes, similar employee,
Supposing they're not fair and they hide things from this court, then what happens?
lordship will pass on.
How do we know that they're hiding things?
Lordship will direct them, my lord, similar circumstances, my lord. Because it is not possible.
Okay,
to work-
so everything depends upon their disclosure.
So is it permissible? They are
No, Mr. Kaushal, let us ask the other side whether there was any revision, that's all.
revision, they see their affidavit. See their affidavit, what is? They say, respondent number 2, humbly begs to state that the Stumberger wage revision salary increments are purely depending on the following facts: performance appraisal, big step training, overall performance. Now, take the case of performance appraisal. Had I been in service, take a minimum, how much I would have got my. Now they've dismissed me from service illegally. That will set aside now. Now they can take the plea. No, since I was not in service, now they cannot do it, my lord. Assuming that's why they said, take this employee as an employment and calculate it. The Supreme Court said. That's the reason. Take him that he's on service, basically. Now, if he was on service, they make a calculation that he was on service without any fault. What will be his commission scope? Appraisal. This thing, my God. There's the issue. Now, under Article 226, we have legal losses, my lord. Not to be more than relief accordingly. Not to be asked there that workman is dismissed until 1990. And apex court says, as if he's on service, if not dismissed. In that case, what will be the normal workman, his promotional scope, benefit, salary, this thing, my lord. Yes, Mr. My lord.
Anything else?
there is judgment in the lottery about back wages.
Huh?
Lawsuit judgment about the back wages.
About
The back wages.
whether it has any relevancy, I don't think.
Now that's only about says about the back wages, paragraph 22. It says the employer entitled for back wages. Now, simple thing is, my lord, calculation. There are 20.
That's all. That's all.
That's all, my lord. Only this part that taking means, had I not been dismissed, would have been there in service, my lord. Then normally, how much work will you get? Just a second.
But certainly not 2 crores.
Yes, 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 yes.
So his only
Yes.
cases, he does not know how much revision he is entitled to. So if the respondents can say what is his entitlement, whether there was any risk, that's all.
I've made a small list of it, only 2 cases.
Okay, very
Only just one example, my lord. One example. There's one Biswajit Park. He was with me during the service. Now in 1998, he got promotion junior crew chief. According to the manual, it is there, promotion post is there. His basic is 4,554 out of meter. That's there.
These are not matters of record. Yes,
I'm-
because
I'm coming under 26, so she may all the relief, my lord. What would be the capital?
No,
These are
but
the
then,
examples.
you see,
there has
one
been
thing.
out of a proceeding.
Now, if you are going to plead something which is not in the record, you are going to take him by surprise. If you are going to use that in support of your submission, that you are entitled to a higher basic pay, then you have to give him notice.
No, I'm saying the reason is, my lord, had I been in service, not being dismissed, normal promotion scope as per judgment of the tax court, my lord, it has to be very clear. That's what I.
But
That's yes. Reason.
Not kindly have the list of it.
Yes.
18/4/1990, petitioner was nominated for service as junior operator. But it's a private company. And other thing is referring to positions where they're all government servants. Increment is not a matter of right. It is, my lord,
this is a private company.
it's a Kumbhangar is a private company.
I tell you the public,
No. The
But this Game on India is same just like in this judgment I'm referring is a Game on India. Same. It's not a government company. Game on India. 84, Supreme Court. Where it says, had I been in service, that's what.
Then 11/2/2013, on a challenge made by the petitioner, Industrial Tribunal Future passed an award in reference against First, holding that the termination was illegal and petitioner was directed to be reinstated in service with effect from 18/4/19 with full back wages within 3. Award was published in the Gazette. Respondent number 2 offered reinstatement to the petitioner in this. In the same course, as per the award with annual basic salary of 19,121, petitioner was asked to join in Mumbai as operation at Nadira was proved. Petitioner informed respondent number 2 that he would join Navi Mumbai office by 12/5/2023. Check for rupees 4,62,738 was entered in the petitioner. Corrected check received by the petitioner to petitioner joined in Mumbai. But after accepting the back wages, he refused to work on the 3 of 11th of his life. And the CD 82 file.
no, but now he was saying he was threatened, being threatened, his life was in danger, so he ran back. That's what he said.
Being agreed by the amount of back wages, petitioner raised the dispute before the assistant labor commissioner by filing an application which was registered as his ID case number 20. And the assistant labor commissioner by order dated 14/10/2014 was pleased to hold that the petitioner is entitled to 2 crore 26 lakh 79,000 extra as component of back wages for alleged non-payment thereof, Pakistan case indicated below was of. Pakistan case was instituted by the petitioner and minister. Pursuant to his notice dated 3/12/14 was issued to the respondent number 2. Pakistan notice dated was challenged by respondent number 3, WPC. So, this honorable court by order dated 13 to 15 was pleased to set aside and quash the Pakistan notice. Further, the petitioner was directed to approach the labor court under 33(c)(2) of the ID Act for redressal of the demand. By award dated 16/6/16, Lalet Labor Court dismissed the claim based on admission made by the government. Award dated passed by the Lalet Central Labor Court below is under challenge in the present litigation. So these are the facts. But there are two propositions of law according to us which call for consideration. The claim of the petitioner for benefit of increment notionally is not tenable on account of the following reasons. Proceedings under section 33(c)(2) of the Industrial Dispute Act is in the nature of an execution and computation of entitlement must be based on an existing adjudication. There is no dispute that there is no existing adjudication with regard to increment by the labor code. Under the circumstances, it is clearly outside the scope of Lanet Labor Code under section 33(c)(2) of the Industrial Dispute Act to execute the dispute regarding any entitlement. Labor Code below, while rendering the ensuing judgment award dated 16/6/16, rightly observed at para 11 that there is no specific direction as regards notional increment payable to the petitioner. In absence of such specific direction, the requirement of law is that the executive court cannot determine the increment notionally. Whether determination, computation of back wages payable to petitioner at 4,52,730 is just and fair also cannot be gone into by the Labor Code under section 33(c) of the Industrial Dispute Act. In any case, Lanet Industrial Tribunal, while passing the award did not specifically directed that petitioner would be entitled to incremental benefit notionally. It would thus appear that there is no existing adjudication on entitlement of the petitioner to incremental benefit notionally. Therefore, its petition is wholly responsive and the same is liable to the dispute. Well, Lordship knows it is a well-settled legal proposition. I will rely upon Supreme Court judgment. The 33(c)(2) is a power given to the labor court to act as an executive court. So it must be preceded by an existing adjudication. If there is an existing adjudication regarding entitlement of incremental benefit notionally, in which event the under 33(c)(2, there can be an adjudication. And we have 33(c)(2). This is the issue actually. Yes. Where any workman is entitled to receive from the employer any money or any benefit which is capable of being computed in terms of money. And if any such question arises as to the amount of money due or as to the amount at which such benefit should be computed, then the question may, subject to the rule that may be made under this act, is be decided by the labor court as may be specified in this behalf by the appropriate government within a period not exceeding 3 months. Provided that where any decision. Now, this provision has been interpreted by the Supreme Court on 2-3 judges. Now, before that, my lord, I'll have your lordship sign attention to the additional affidavit filed by us. Because while issuing notice, certain observations were made. So therefore, my lord, in question to that, we filed that additional affidavit. Please come to para 2 of the additional affidavit. Para 3. And this Bloomberger is my lord. It's not a government entity. That the respondent number 2 humbly begs to state that in Bloomberger wage revision salary in
Gentlemen.
sorry,
Additional affidavit on your phone number
dated
2.
19/6/2018. Filed by respondent number 2. This was pursuant to this honorable court's order.
Yes. Para?
Para 3.
Yes.
That the respondent number 2 humbly begs to state that in Bloomberger wage revision salary increment are clearly depending on the following factors. Bloomberger annual performance appraisal, six-step training program, overall performance of Bloomberger Group at the global level. In Bloomberger appraisal process, in a Bloomberger appraisal process, employee has to record his specific and measurable objective in the appraisal system at the beginning of the year, which is reviewed and agreed by both employees and his manager. Thereafter, achievement progress respectively for each objective is filled by the employee and reviewed with the manager on quarterly basis. Wherein feedback is given both on results, on objectives and other performance factors. At the end of the year, employee is evaluated on the basis of the results relating to the agreed objective and also an evaluation of other performance factors by management. As a result of evaluation, the employee's performance is rated as per policy. In the following year, company management decides on the budget for the salary revision and increment depending on business condition and profitability. Company in some years allocate budget for increment, which is typically distributed based on individual performance rating. In fixed training program, employee has to successfully complete the various trainings such as the online training module, on the job training project and classroom training and other related certifications, most of which the concerned person will be eligible for promotion and wage revision. Considering the above scenario, it is clear that as per company's policy, there is no definite and fixed increment cycle that every employee is entitled to, and the increments are completely dependent on capabilities and performance. Consequently, B.P. Roy, petitioner is not entitled to any wage by default since he has not been in employment since 1990 and no performance review was due because he has not undergone either of the process. One has to undergo for wage revision, salary increment and improvement. Only if my learned client is unhappy with this, he can challenge. But this is the position. Now let us see what is the legal position. Supposing, my lord, there is an order that he is entitled to tax. Does it necessarily follow that he is entitled to implement? Well, this 2 crore is an astronomical figure. So there is no question. Then my lord will kindly come to take 3 decisions of the Supreme Court. First, I think these judgments are there, we have given. First, my lord will take 2003, 2 SCC 2012, 212. This is AP SRTC versus Narsago.
Yes.
Yes, please come to para 9, my lord.
Yes.
We find merit in the submission so made. There is a difference between an order of reinstatement accompanied by simple direction for continuity of service and a direction where reinstatement is accompanied by a specific direction that employee shall be entitled to all consequences which necessarily flow from reinstatement or accompanied by a specific direction that the employee shall be entitled to benefit of increment earned during the period of absence. In our opinion, the employee, after having been held guilty of unauthorized absence from duty, cannot claim the benefit of increment notionally earned during the period of unauthorized absence in the absence of a specific direction in that regard, and merely because he has been directed to be reinstated with benefit of continuity in service. So, these are not automatic. If there is a specific direction that you be entitled, then there is another question. The second judgment in law, 2005, 6 SCC 36.
Six, six, eight.
Yes, madam. 2005, 6 SCC, page 36. Andhra State Transport Corporation versus Abdul Karim. Yes. Please come to para 10 and 11. Para 10 and 11. The principle of law. The principle of law on point are no more res integra. This court is S. Narsa Gaura succinctly crystallized the principle of law in paragraph 91, which I read before. Let this come to para 11. Reverting to the facts of the case at hand, as already noticed, the labor court specifically directed that the reinstatement would be without back wages. Here, of course, there was no question of. There is no specific direction that employee would be entitled to all consequential benefits. Therefore, in the absence of a specific direction in that regard, merely because an employee has been directed to be reinstated without back wages, he could claim benefit of increment notionally earned during the period when he was not on duty or during the period when he was out of service. Now, the last sentence very important. It would be incongruous to suggest that employee having been held guilty and remain absent from duty for a long time continues to earn increment though there is no payment of wages for the period of absence.
It's not applicable to the case.
Anyway, here in this case,
Is it the earlier one?
yes.
Fine with that.
No, earlier one will apply, Melo. That was a case of all consequential benefit. Earlier one, he'll entitled to all consequential benefits. Para 9. Of course, my lord, the 2005 6 SCC is a case where the direction was not all. Then my lord will kindly come to next case.
It is during the period of unauthorized.
Yes. No, 2000, this 2003 2 SCC page 212, here the direction was reinstatement with all consequential benefits. There the Supreme Court has taken the view, if a specific direction is, unless a specific direction is there, there is no. Then we note on the scope of section 33C2, the judgment 2005 8 SCC 58. 2005 8 SCC 58. Para 7, 8, and 9. The party's name is State of Uttar Pradesh versus Brispal Singh. It is well settled that the workman can proceed under section 33C2 only after tribunal has adjudicated on a complaint under section 33A or on a reference under section 10 that the order of discharge or dismissal was not justified and set aside that order and reinstated the workman. This court in the case of Quenco versus Quenco held that a proceeding under section 33C2 is a proceeding in the nature of execution proceeding in which labor court calculates the amount of money due to the workman from an employer, or if the workman is entitled to any benefit which is capable of being computed in terms of money, proceeds to compute the benefit in terms of money. Proceeding further, this court held that right to money which is sought to be calculated or to the benefit which is sought to be computed must be an existing one, that is to say, already adjudicated upon. Only that money part is needs to be computed. That entitlement is already adjudicated. What is the extent of that amount? Or provided for and must arise in the course of and in relationship between the industrial workman and his employer. The court further held as follows. It is not competent to the labor court exercising jurisdiction under 33C2 to arrogate to itself the function of an industrial tribunal and entertain a claim which is not based on an existing right, but which may appropriately be made the subject matter of an industrial dispute in reference under section 10 of the Act. In case of municipal corporation, so and so versus so and so, this court held. The High Court has referred to some of these decisions and but missed the true import thereof. The ratio of these decisions clearly indicate where the very basis of the claim or entitlement of the workman, where certain benefit is disputed, there being no earlier adjudication or recognition thereof by the employer, the dispute relating to entitlement is not incidental to the benefit claim and is therefore clearly outside the scope of a proceedings under section 33C2 of the Act. And will not may kindly skip this. Please skip over to the next page, para 8. Towards the bottom. The principles enunciated in the decisions referred by either side can be summed up as
No, no, para 8.
para 8 at page 5. The principles enunciated in the decisions referred by either side can be summed up as follows. Where a workman is entitled to receive from his employer any money or any benefit which is capable of being computed in terms of money and which is entitled to receive from his employer and is denied of such benefit, can approach labor court under section 33C2 of the Act. The benefit sought to be enforced under 33C2 of the Act is necessarily a pre-existing benefit or one flowing from a pre-existing right. The difference between a pre-existing right or benefit on one hand and right or benefit which is considered just and fair on the other hand is vital. The former falls within the jurisdiction of the labor court, exercising power under section 33C2 of the Act, while later does not. It cannot be spelled out from the award in the present case that such a right or benefit has accrued to the workman, as specific question of the relief granted is confined only to reinstatement without stating anything more so as to back wages. Hence, that the relief must be deemed to have been denied for what is claimed but not guaranteed necessarily gets denied in judicial or court action. Further, when a question arises as to the adjudication of a claim for back wages, all relevant circumstances which will have to gone into are to be considered in a judicious manner. Therefore, the appropriate forum where such question of back wages could be decided is only in a proceeding before a forum to whom a reference under section 10 of the Act is made. To state that merely upon reinstatement, a workman would be entitled under the terms of the award to all his areas of pay and allowance would be incorrect, because several factors will have to be considered as stated earlier to find out whether workman is entitled to back wages at all and to what extent. Therefore, we are of the view that High Court ought not to have presumed that the award of the Labor Court for grant of back wages is implied in the relief of reinstatement, or that award of reinstatement itself conferred right for claim of back. And of the law, if I understood correctly, the 33C2 petition in a proceeding, a labor court, unlike an industrial tribunal, who will again decide pursuant to reference under section 10, will only compute the money that he is entitled to particular benefit under a particular head. Is already there is a pre-existing adjudication. It is only then that a workman can go to the labor court and file a petition under 33C. In this case, in my humble submission, there is no pre-existing adjudication that the petitioner is entitled to increment notionally, which is his claim. And in a government office, things are different, where increment is a matter of course. Of course, in government department also, there is a requirement of overcoming the efficiency bar and all. But then, more or less, in government offices, my lord, these are automatic. Now, here there has to be specific direction. In that case, if you want to, you can't go to industrial tribunal to say that no, you are also entitled to incremental benefit and also ask the labor court to compute. Please bring that both. Learned labor court said, sorry, this is not permissible. Well, merely because this honorable court asked him to go to 30, file a petition under 33C2, that by itself will not float him with any right. If that was his case, then he should have got a reference under section 10 that this declaration must include everything. Because it was not clearly reflected, that's why I'm facing this problem. You should have gone. But in that view of the matter, in my humble submission, it would be too much, my lord, on the part of the petitioner to expect that your lordship, sitting in 220 jurisdiction, my lord, will compute that and give it to the petitioner. It's not possible. And finally, see what is wrong in the tribunal's order, my lord. Sorry, labor court order. And we come to the interim order of the tribunal, labor court. Right? Yes, one second. Yes. Now, please come to page 78. Para 5. I have heard the learned counsel for both sides.
Yes.
I have heard the learned counsels for both sides. I have also gone through the evidence on record and submissions made by both parties. Learned counsel for the petitioner DMR has fairly admitted and submitted that the claim made in the claim petition is excessive without supporting document, and as such, the said claim is not made in evidence on affidavit. However, he claimed that petitioner is entitled to his 105 rupees per day as food allowance, and he is entitled increment, and he is entitled to increment on salary for period of 23 years and 8 months. My lord, where from this 23 years comes, my lord? He was dismissed from service on, I think, 90. He was reinstated in 2013. So, my lord, when he came to the court, he's counting everything. Thereafter, he has not performed the job. He left. After taking the draft, he left Mumbai. So, where from this 23 years come? Thereafter, you must perform. Then only you will get your wages. The period, the only period of dispute is between 19/4/19 and the date of the award passed by the elected. In between that period, what is entitled? Thereafter, he has not performed any job. Neither he has worked. He further submitted that the opposite party, while computing back wages, has not computed food allowance and increment, pointing out salary certificate exhibit 1 in the name of the petitioner. He submits that computation could have been as per exhibit 1. However, opposite party, while computing back wages, has not considered some amount mentioned in the pay slip. He also submits that labor code has power to notionally determine the increment while computing the back wages. This is the case, man. He also submits that labor code has power to notionally determine the increment while computing the back wages. Now, he admits that increment portion was not directed by the industrial factory. So he says labor code is competent to notionally determine. It is in that background. Now, Lordship will kindly come to paragraph 6. Will decide. On the other hand, learned counsel for the opposite parties, Mr. Dipam Bora, has approved that management has already paid back wages and the same has been accepted by the petitioner without objection. He further submits that what was been claimed by the petitioner, his claim petition has not been claimed in evidence, and there is no calculation sheet as regards back wages. He further submits that in absence of specific order in the award by the labor court, this court cannot fix the increment. He further submits that there is no supporting document as well as evidence to the effect that the petitioner is entitled for food allowance. In support of his argument, he relies on transport. Then Lord will kindly come to page number, I'll have to read para 8. The claimant Vibhu Bhushan Devroy, in his evidence, stated that he was appointed as a junior operator grade 3 by management of Messrs. Schlumberger Asia Services Limited, and the service were confirmed on 10/7/88. After confirmation order dated 10,788 is monthly salary with effect from 1/7 was as follows: basic salary 370, dearness allowance 296, HRA 450, 20. As overtime rate of rupees 7.24 per hour, 20. These are the other components. Amount of back wages with effect from 1190 to 3414 payable by, so this is the relevant date, madam. This is the period for which he is entitled. Payable by the opposite party to him stands at 2,31,000, sorry, 2 crore 31 lakhs, etc. But the management has paid only 4,75,084, which includes subsistence allowance of rupees 2,849 paid on 6/5/92 and 19,000 and odd paid on 19/5/22 during suspension and 4,50,738 by due on 25/14, and thereby the management has not paid 2 crore 26 lakh 79,000 illegal. He is legally entitled to get so and so, so and so, so and so. In his cross-examination, he stated that he joined the company on 1/7/87 as a probationer. His service was confirmed on 88. He joined as junior operator grade 3. His total salary at the time was 1,583. So. Schlumberger Asia Limited is the name of the company mentioned earlier. Schlumberger has been mentioned there. It is not a fact that he himself did it. Signature mentioned in Exhibit 13 is not there. There is no official, no seal is used in the letter of the company. It is not a fact that Exhibit 13 is made up of documents. He claims rupees 2 crore and odd as area by so does not mention that it would have retrospective effect. After termination of his service, he had filed a case in Silchar Labor Court for reinstatement in service with back wages. Labor Court allowed his reinstatement in the same brand with back wages. The quantum of back wages was not quantified. Now the office of Schlumberger Asia is closed, but work of the company in Nadira is going on. On 3/4/14, the company asked him to join in Bombay office judicial. Okay. He submitted joining report of he submitted medical certificate for not joining within the specified time. He has not submitted the medical certificate in his case. That joining report has not submitted in his case. On 14/5/14, he went to Dubai and submitted the joining report, but they gave him offer letter and asked him to accept it. On 14/5/14, he was given rupees packages and he did not receive it because the name was wrongly mentioned. He was given a press correct checkout, a press check with correct name and he received it. He objected but not in writing. On 25/14, he was forced to give a letter mentioning that there will be some delay in joining due to illness of his wife. He was threatened and assaulted when he went to join there. He did not know their names, so he returned home. He filed FIR after returning home against the person who guided them and were in presence he threatened and assaulted. It is not a fact that the said claimer has no basis in judgment, etc., etc. Then my lord, at page 81-82, a different component of the service is explained. Now, my lord will kindly come to page 84. This is very important. Please come to para 10. The claimant, while adducing evidence, has well altogether exhibited 13 documents. However, except exhibit 13, other documents are photostat copies. Learned counsel for the opposite party has disputed genuineness of exhibit 13 as there are some correction without seal and signature. As per exhibit 13, net pay of the petitioner at the time of dismissal was 4,174. Even if the aforesaid amount is considered to be salary of 50 at the time of dismissal for computing back wages, or as to consider his basic salary, PA, and fill allowance, which has been accepted by the management side. Management side has computed the back wages on the aforesaid salary. Petitioner has claimed that he is entitled for field allowance. However, there is no documentary evidence that he is entitled to fill 11. In the pay slip also, there is no mention that he is entitled to fill 11. Apart from that, there is no calculation seen from the side of the petitioner as to how much he is entitled to have back wages in different years. Learned Labour Court, while passing the award, has made it clear that petitioner is entitled for reinstatement with full back wages from the date of dismissal. However, there is no specific direction as regards notional increment of the petitioner. In absence of such specific direction, the requirement of law is that executing court cannot determine increment notionally. In such circumstances, petitioner is not entitled to increment. From the claim petition as well as evidence on record, the admitted position is that petitioner has already received an amount of rupees 4,52,738 only as back wages. Paid back wages was paid by the management as follows. So basic was 390, dearness allowances was 312. Then HRA was 550 till allowance rupees 331. So total is, my lord, 1,580. That was around that time. That was even our judicial magistrates were also getting very less. So it comes to, if we multiply it by into 20 years, 8 months, it comes to 10. The computation made by the management is in accordance with the pay slip issued to the petitioner, and the same is acceptable in view of the facts and law. From the above discussion, I am with you that there is no merit in the petition under section 33C2 of the ID Act, and same is dismissed without. What is wrong with it? My humble submission, there is nothing wrong. So court says, the labor court says, my lord, I cannot compute it. Your claim regarding notional increment, fixation of increment notionally, that is not a claim which has been given. In any case, in our organization, increment is not automatic. To earn increment, you have to perform.
It is not given to everyone across the
Yes,
board.
it's not a matter of, automatically one is not entitled to it. If he was so conscious of his right, then in the first proceeding before the industrial tribunal, when a reference was made under section, then all these points should have been taken up. When you got an,
So can't he take it up again?
my lord,
Can't he take it up again?
I think limitation is there because I think those are, if it is otherwise in law, it is found as a defective. At least, my lord, end of the day, it's something like this. Why then order to move to the term can be successful? Now, if you have got several cause of action, you must put all these cause of actions in one. Today you cannot say, they give me back wages. Tomorrow you cannot file another petition for incremental benefit. There has to be an adjudication that yes, Vibhu Bhushan Debroy on his reinstatement is entitled to X, Y, Z. Once that adjudication is there, then in a petition under 33C2, the labor
But
court can
won't full back wages amount to all that?
no, no, in a private organization, certainly. I can appreciate it is a government
Automatic application. is-
it's not. And our policy, let's say, there's a observation of this honorable. Okay, fine. And there is no reply to that. That stands unreported as of. End of the day, my lord, the amount of salary he was receiving in, 1990, and the amount which he got pursuant to the order, I think it comments to it. So to say that, that it is, it is less, of course, my lord, in this context, it is less. You have to consider in the context of 1990. And plus, therefore, he never joined. Once he got the chair, draft, he left on the plea that his wife is not there. Actually, my lord, when court directs reinstatement with full back wages, he has a duty to discharge his functions also.
He left on ground of ill health.
No, illness of wife. After initially, my lord, when the draft was given, there was something wrong in the name. So we corrected it, we handed over him. Then he said that my wife is not well, I'll have to do. Thereafter, he never turned up. Is that the purport of that award of the industrial tribunal? That you are reinstated with full back wages? Was that the purport? And let's see the conduct.
He says that his life was threatened. So he went back
Then he
to
said it.
Silchar and filed a,
police complaint.
he
there.
filed a FIR in Silchar.
He said, no, he should have filed a police complaint in Bombay.
And,
My lord, how can a
Sil-
operator is taking?
and Silchar police sent it to Bombay.
Exactly.
What happened to that FIR? No idea. You don't even know the number. What is the number of the FIR?
FIR, I have annexed the copy here, right? I have copy, I have annexed.
So I'm told, my lord, the FIR was first by the Bombay.
Complaint of
Was,
FIR of what?
was. So lordship, once we can find out the number of that our order, it's number.
You know that? Yeah.
No, I don't know.
Well, the problem now, according to what Mr. Chaudhary has said, is that it is a private concern. And there is no automatic giving of revision of pay. They are earned individually.
Answer it.
Well, before that, just one thing, my lord, that in the second case where there was a judgment for only reinstatement without tax, the second judgment which I relied upon, there Supreme Court made an observation. If a person is not in service, Supreme Court says it will be incongruous. That paragraph, that's I refer to that judgment only for that limited purpose. Supreme Court said it will be incongruous on the part of an employee to insist on increment for the period in question. Right or wrong? Only for that limited purpose, sir, I refer to that.
Especially if it relates to government servants,
Yes,
it automatically comes in.
yes, same, but not in a private organization. And why not kindly see it, thereafter, if you would have stayed in the organization, you would have performed, then he himself would have known how increments are. He just cannot.
So he hardly worked in the,
Yes.
just 88,
For
87. 87 he was appointed, 90 suspended.
1904.
94, 90, 1990 he was terminated, 3 years. Anything else?
That's my answer.
My lord. This part, page number 84.
84.
Just I'll finish, my lord. In small campus.
How much- How much time?
It will not take us. 2 paragraphs I'll read and then I'll. Page 84, paragraph 11 in the operative part. My learned friend has read, and I also read it. Where? Page 84, paragraph 11. First line. Learned trial court, by passing the award, has made it clear that petitioner is entitled for reinstatement to full back wages to the date of dismissal. That opposed here. Now, Lordship is saying, reinstatement to back wages. I went there in Bombay. A lot of difficulty, they reinstated me. The lower category court. 80 anyway, I am not.
That is not an issue you have raised here.
No, it's not right. I'm just saying, I'm saying what they conduct. Not only my conduct, look at the conduct. They've done it here. And what difficulty I face, that's a different issue. Now, so far the back wages is concerned here. These back wages, Lordship, I'll raise the Lordship's my lord to read along with paragraph 4 of that Government Act. It's not a comment organization. Exactly this is the answer. How your Lordship, now Lordship is sitting under 226, and this is decided under 226. Can you see? Paragraph 4 of Government India 1984 1. My lord, middle, let me say, respondent would be entitled to all back wages, including the benefit of revised wages or salary. If during the period there is a revision of pay scales with yearly increment, revised dearness allowances, or variable DNA allowances in all terminal benefits if he has reached the age of superannuation, such as provident fund, gratuity, and so that. Back wages, this sentence is important. Back wages, my lord, should be calculated as if the respondent continued in service uninterrupted till the reinstatement date, uninterrupted. Therefore, my lord.
Yes, yes.
Solution is got it, no?
Yes.
Yes. Back wages should be calculated as if the respondent continued in service uninterrupted. He is also entitled to leave encashment and bonus if other workmen in the same category were paid the same. It appears that respondent has been unlawfully kept out of service. Therefore, it is but just that the applicant company shall pay all areas as calculated according to the directions given here with 12% interest from the date of amount become due and payable to realization. Applicant shall also pay cost. Here is my entire case based on my. This fault will be attributed to whom, my lord? To me. They dismiss me illegally. They don't remember the dismissal order. Matter are referred to the industry tribunal. Industry tribunal said setting dismissal is illegal. So passed out of reinstatement with back wages. Now the back wages interpretation, my lord, was to be getting here in my other judgment also back wages. The other one I have given. So I'll make my submissions rely, put in the paragraph 4 basically, my lord. It includes whose fault it was. Was my fault that terminated me from service on that day? It is because of you I am suffering. Till today I am suffering. I become poorest and poorest I have become. Lord, difficult and running. The effects courts. Entire back wages benefit. Says my lord, as if he is on service by. Lordship may consider this part, my lord. This is the interpreted by the effects court. Back wages, what is back wages? In this two doesn't. That's my subject. There is the actually, my lord, the entire case rests on this, my lord. Whether he's entitled for back wages or not. Effects should absolutely be clear. Had they not dismissed him, I would be sorry. In calculation part, how is to be done, my lord? It said he is also entitled for leave encashment bonus. The other work, if other work in the same category.
Okay, come to 105.
Yes, not mine.
105.
Yes, 105 page number, page slip, and list. I've shown to you, Dr. 105. So this is of 1989.
Basic salary.
Yeah, basic salary. Right side, you see top 1989. So revision, apex code says paragraph 4, that has been answered by the apex code. They cannot stick to that 20 years back what person was doing. And this is what not government doesn't make. It's a game on India, my lord. Just like this one. That's the current thing.
But if they're not, there was no revision of your thing. There was no revision of the basic thing.
Revision is based on performance. That's what they have indicated it.
Now, whose fault? That performance I could not do. Is it attributed to me? No.
But then what to do? May not be attributable to you, but then what to do?
There are, now how it will be calculated? It will be
But
calculated.
what about DNS allowance? DNS allowance will be saved.
Yes, sir, that will be well. That we have focused.
No, this everything will come up.
So, DNS allowance, we have focused.
As per the latest.
It will, no, my lord. It will come up.
HRA also.
The last page of the order of the labor code that area,
312,
Page,
last page of the implementation.
page 80 something.
Yes. Page, I think 84.
84A.
page 84. 312. Now, can you see page
84A.
105, 312 of 89? Not revised. That is my entire claim is this. Entire calculation is on up to 89.
No, the problem is, they are saying that this is the correct amount.
Why
They-
they say
they-
correct?
they-
Because they said because of the appraisal procedure, I have not gone through that process.
Huh?
No, they say there is appraisal procedure, other things are there. Had it been service, that could have done. Now, I was ousted by them illegally. I cannot force them to go to the office and sit finder. Whose fault was this? Can the fault be attributed to me? It cannot be my lord.
No,
Normally,
I'm not on that. You're completely, you're white as snow. Say, you're white as snow. No black spot.
assuming, yes.
Okay.
Then calculation part.
Now the calculation part. Now they are saying that this is the method that we follow
Now, if they have not followed that, had they not.
Now, how do we know they have not followed?
No,
That's
had
the
they-
problem.
now it's only one point now. Take that I am in subject now. Let me consider I am in subject. Not, I have not been, my lord, dismissed or terminated. Now, normally see, what will be my promotion respect of which year, my lord, they must calculate that one. Because it was there, they did not do it because I was forced to kept out of some.
Promotional prospect is not an issue here.
Now,
It's
now,
only back
calculation,
when
only the calculation part. Actually.
that's what, and according to them, there is no, the concept of revision only applies to individuals, not across the board. That's what they're saying.
No, if I have been kept out of something, am I responsible for this? Am I, as what the FS code says here, this
But
paragraph
then-
four,
But what to do?
so this, Lordship will direct them, my lord.
To do what?
Had I been in service normally, my lord, what will be my prospect, my lord? How can I calculate this one, my lord? Because I am ousted from service. They kept me ousted for 14 years. And they're in statement because of the order of the tribunal now. Now this 14 years, let me calculate as a normal person how much you get. That will be calculated. Can it be up to me, my lord? I am a workmanship workman. Can I go to the office and fight over the officials? No, this cannot. There's a Lordship sitting here, my lord, to help this workman. No, what is the poor people, but yes, 2 crores is too much, my lord. I'm not on that. My lord, I said, no, my time. He said 2 crores, even the petitioner council also I found, my lord. That's it. That's good. But something isn't good. What I mean, it's been dismissing, what property to don't even give me a dismissal order was not anything. Not familiar is directed by industry found out the thing. Nobody was examined. Nobody came forward in the court to give evidence. Nothing. That's why it was set aside. It's a reinstatement.
Was there any person who had joined on the same day as you or joined?
That's one I gave one example. That's why they could have
But that
taken.
is not part of the record.
It's not so under Article 226. Lordship has got long hand, my lord, to reach this type of
But
situation.
that
to
has
deal
to
with.
be a part of your pleading.
Pleading is
Can you
not
make
there.
submission beyond your pleading?
If the apex court has said, similarly situated persons, apex court did not say, you petitioner go and find out one person, pick up their similarly situated person. Apex court did not say so. I will rely upon the authority, my lord, the big companies, my. At least be there and come. How much? Maybe little less also. It's not too good. Something. At times, Lordship will direct my lord, Lordship will see in the MS indicated. No, he's entered about.
How much is that other person getting?
Other person in 1989, his basic salary is 4,554.
1989.
1989, this is
But 1989, you're
not 1998. 1998. This person, Vishwajit Palmer with me in CTF together. So just an idea, my friend. See, here's the basic salary. 390 in 98, 4,554.
Same,
He got promotion. No, he got promotion. And that is,
his promotion.
yes, there are also promotional chart is here. They got a chart promotion.
Okay, so he was promoted. But no, at that time, what was the basic pay of the person?
390. Basic pay
Of the person?
Basic
of-
1989. This is the promotional post, junior to member, my lord. That is not there, my lord. It is, they can say, my lord, all that. Because I, in the workman, it is impossible for me to fight with a giant company. Lordship kindly consider this point, my. The poor persons, my lord, where they will go? Is it possible for him to do this, my lord? Absolutely, Lordship has a relaxation, my lord, to help these people, my lord. It is said, my lord, your Lordship's hand,
Yeah,
226
uh,
is too long.
Just a minute. Mr. Chaudhary, in this order dated 17/5/2018.
Yes.
It has been stated that by this order dated 17/3/2017.
It pays me, lord.
No, it's the order of this court. This court had directed the respondent number 1 to furnish the revisions that have been made to the basic pay of the 396 year 1990,
Yes.
along with other admissible allowances attached towards salary in the form of affidavit. Now, has this been furnished? No, because on the basis of that, maybe there can be some upward revision and difficulty. This is 17.
7518 order.
17/5/18 order.
Yes.
Correct. That is there in 17 also.
That is, again, order. Anyway, my lord, it's a civil proceeding. So he has to prove a document in order to get a bank. He has paid.
No, that is all right, but then the order,
What your lordship is deciding for. If 33C petition was rejected from the town, that we cannot know. What is the wrong? with it? He may have other remedy, he may have other remedy. That's a different aspect. That's not different. What is this your lordship? And 226 petition arising out of proceeding under 33C. The learned labor court say we are nobody here to compute. We are only to compute what is the amount paid. So labor was paid was court found it okay. And they want that no. They want something more. No, I'm very sorry, I could have placed one judgment. I think I've given it on the last page that how to compute back wages it is given. This is 2007, 2 FCC 433. KK Synthetic Limited versus KP Agro. How to compute back wages in such a situation? I'll hand over my copy. I'll just reading it, just small paragraph. Then I'll hand over the copy. Para 17, 18, and 19. Now, can you take note of it? 2007, 2 SCC 433, para 17, 18, and 19. Coming back to back wages, even if the court finds it necessary to award back wages, the question will be whether back wages should be awarded fully or only partially. That depends upon the facts and circumstances of each case. Any income received by the employee during relevant period on account of alternative employment or business is a relevant factor to be taken note of while awarding back wages. In addition to the several factors mentioned in 12, therefore it is necessary for the employee to plead that he was not gainfully employed from the date of his nomination. While an employee cannot be asked to prove the negative, he has at least to assert on oath that he was neither employed nor engaged in any gainful business or venture, that he did not have any income. Then the burden will shift to the employer, but there is, however, no obligation on the terminated employee to search for and secure alternative employment, be that as it may. Then para 90 was the last portion. Therefore, where reinstatement is a consequence of imposition of a punishment, neither back wages nor continuity of service or consequential benefit follow as a natural or necessary consequence of such reinstatement. In a case where misconduct is held to be proved, reinstatement is itself a consequential benefit arising from imposition of lesser punishment. Award of back wages for the period when the employee has not worked may amount to rewarding the delinquent employee and pushing the employer for taking action for misconduct committed by employee. That should be avoided. Similarly, in such cases, even where continuity of service is directed, it should only be for the purpose of pensionary, retirement benefit, and not for other benefits like increment, promotions, etc. So, my lord, the idea should be there should be continuity of service so that these pensions can be computed and all, but not to do increments and promotions. I'm handing over this topic.
but revision is not there.
No.
Revision is not there.
Except like it says except.
But what do you think of this order of this court passed
Yes.
earlier
Yes.
on 17/5/18?
That to that we have filed a reply, my lord. That additional affidavit was a reply to that. 19/6.
That is
That is all.
individual bill.
In fact, precisely pursuant to that order, we filed that addition.
Huh? Huh?
That part is not there, basic color is not there.
Basic?
In the affidavit, it is not there. The basic, Lordship wanted to know by this order, what the basic
Not there in the affidavit.
In the absence of performance, they could not have revised this pay. So our policies, everything is based on, it is a private company. We are
No, but then if the basic pay must have been revised for new entrants.
Right.
But it's your,
No, my lord,
earlier you got
it all, it
270.
all depends upon person to person. It's not that somebody, all clerks should get equal. Some clerk may be getting more, some clerk may be getting less.
What to do? This is like a private company.
No, but
Now,
this government is
unless-
also a private company.
Unless you are able to show.
No, my love, that my understanding is referring to Gabon India's case. That is a case under section 25 Act.
Okay.
Yes, that's a case of request. The case under 25 Act.
Equities.
So that's not a determination under 33C2. Toxic is concerned with the determination of the 33C, whether the labor code was wrong. That's the only point. Whether the labor code was wrong in saying, in the absence of any specific determination with regard to notional fixation of benefit increment, whether labor code was wrong. That's the only point. I don't think.
Can we take a larger perspective beyond what the labor code has done? No, what is it? This is a rich jurisdiction.
If we go by the spirit of section 11 of the Industrial Dispute Act, possibly not substitute. So that's the difficulty. Basically, Lordship will examine the decision making. Whether the labor code was in error in deciding the 32 application in the manner it is. If a Lordship finds it is wrong, Lordship will demand it. Otherwise, not. Because Lordship will not substitute the fine. Because there are no materials before law. Onus was on. It's a hard case, but that my lord, law is law.
Or about this gainfully employed, my landlord can raise this fee, not gainfully employed or not gainfully employed. That will be answered by the trial court, my lord, labor industrial court in page number 40. We pleaded in the petition. We are not gainfully employed, and that has been upheld by the page number 40. Page 40. No, I'm saying, but here we have taken
Page
this fee.
40.
Page 40, yes. This plea we have taken in the petition, that will be answered by the learned tribunal. Page 40.
This is what in the earlier.
Yes,
round?
earlier, yes.
Earlier round.
Yes, because initially Lordship will take this point.
Page 40.
Page 40.
Yes.
Bottom.
Yes.
Now it is settled law that to get full back wages or half back wages, etc., it is burden on the management to prove that workman was employed, and if employed, he was gainfully employed. In the pleading, the workman states that after loss of his only means of livelihood, he was not gainfully employed in any other establishment. In evidence, he states that after termination, he and his family members have been pulling the days of starvation, and one of his sons died as he failed to provide him treatment. But in cross-examination, he states that he has inherited land and building jointly. He had a car purchased in the year 2007, price of 3,53,000. His address is such and such. My lord, then Lordship will find, third line, next page. Having a car purchased on loan, having a daughter studying in the university, living in a building inherited from his father, does not infer that workman is employed. He specifically states that.
Okay. Anyway.
That's not mine. So since Lordship is passing judicial order, at least say how much basic pay, my lord. This is a judicial order, my lord. Not for anything else, Lordship has passed the order.
Okay.
Lordship wanted to provide certain relief to this workman, my lord. At least basic pay of 1990.
I can only decide a matter on the basis of the materials before.
Then on the judgment of the effects law. Wages means wages, payment of wages as it comes by law. It's maybe 25.
Correct. But
Yes. So on the basis of this paragraph 4, my lord, revision. What is that?
that is what they've answered. They are saying that we don't give revision broad-based. We give it on individual.
Can it be like?
What to prove your case? This is not a normal writ petition.
But-
This is with regard to what whether there's any wrong.
Then what apex code is saying? Apex code, see, kindly see this paragraph 4. He's entitled to leave and decoy just if other work with same category we are paid the same. Here also there is no evidence saying that other persons got this in this case.
Why didn't you lead the evidence to that effect?
In this case also there is no evidence. It is the apex court says so. High court says so. That is upheld by the apex court, my lord. Paragraph 4 is very clear. Entire case rests on paragraph 4 of Cayman India. It's private company.
Anyway, let me see.
My lord, kindly take it at this point. Where will go this poor man? Can he fight with this such a huge elephant, my lord? He's an ant, my lord, small one. This is huge elephant.
Without working, he's got a car, he's got building.
No, my lord,
He's unemployed.
that is his own building. What is his mind?
And he's,
Now I know
he's-
now he's staying in his son has got a job recently. He's staying in the rented house. I know. Now, not the
he employed a very good lawyer also, senior advocate at that.
My lord, senior advocate by name shake only now, my lord. In this case, I don't say what happened, my lord. Let's keep it.
Okay, right. Heard Mr. M. Nathur, Leonard, senior counsel for the petitioner. Assisted by Ms. D.L. Dick. Also heard Mr. K. Chaudhary, Leonard, senior counsel for the respondent, all the respondents. Respondent number 2. Respondent number 2. Who is respondent number 1? Respondent number 2. Assisted by Mr. Tibor. The petitioner's case is that pursuant to the order dated 11/2/2013 passed by the Industrial Tribunal Filter Kachap in reference case number 3 of 2008, the petitioner was reinstated back into service with full back pay. Now, reinstated back into service with effect from 18/4/90. Is it 18/4/90?
Yes.
With full back pay.
Yes.
Good. However, the petitioner's grievance is with regard to the calculation made by the respondent in awarding him, while awarding him the back wages, in as much as the same has been calculated on the basis of the petitioner's basic pay in the year 19, at the time of his termination from service, that is at the rate of rupees 390 per month. Next one. The three facts of the case is that the petitioner was appointed as junior grade C in MS Schlumberger Asia Service Limited, a company registered under the company's act. Under the Hong Kong. Oh, then what are you saying? Your position is this. Oh, registered under the Hong Kong? Under the laws of Hong Kong. So the petitioner was appointed on 10/7/1998. And on 1/1/1990, he was placed under suspension, followed by termination from service with effect from 18/4/1990. The dispute between the petitioner and the respondent number 6 was referred to the Industrial Tribunal, Session for adjudication, wherein it was registered as reference case number 3 of 2000. Next, the, reference case number 3 of 2008 was disposed of by order dated 11/2/2000. That is, by reinstating the petitioner with effect from 18/4/1990 and granting him full battery. Subsequent to the above, the response number 2 paid rupees 4,75,084.70 to the petition as full and final settlement of the weightage and did not pay uh, settlement of the weightage. Being agreed, the petitioner approached the Assistant Labor Commission for payment of full back wages amounting to rupees 2,26,78,177.30. By taking the stand that the respondent number 2 did not include any increment slash allowances or revision of pay while paying the petitioner rupees 4,75,084.70. Next. The Assistant Labor Commissioner thereafter directed the certificate officer to Pixaga to recover an amount of rupees 2,26,78,177.30 with interest from the respondent number 2. By letter dated by what? By certificate dated 14/10/2004. Being agreed, comma, that is the writ petition. Being agreed, the respondent number 2 approached this court by WPC number 6842/2014 trying to set aside the notices and proceedings in Bakijai case number 70/2014 initiated on the basis of the set initiated on the basis of the uh, order dated 30/9/2014 issued by the Assistant Labor Commission for recovery of rupees 2,26,79,177.3. Next,
Where I take it, the evidence given by their officer for the fact of where it says it did not calculate the take weight. Take weight is calculated by the industrial relation officer.
No, I cannot go into those. Motions. The flow goes. Next one. This thought, this holds of WPC 6842/2004 by order dated 13 to 2004, 2015. By holding that it was an athletic position that in the adjudication process made by the Assistant Labor Commission, holding that there was holding that the point number 2 was liable to pay to the petitioner rupees 2, 26, 79, 117.30. Is the amount correct? The petitioner, no, the point number 2 was not associated with the adjudication process. The learner, this court thereafter, disposed of the writ petition by setting aside the notice, notices dated 3/12/2014 issued by the recovery officer, certificate, no, and certificate dated 30/09/2014 issued by the Assistant Labor Commissioner, and Pakijai case number 17/2014. As this court in its order dated 13/2015 also reported the fact that the petitioner had undertaken to file an application under section 33 bracket 2 of the Industrial Disputes Act 1947, hereinafter referred to as the Act, with regard to non-payment of the entire battery. Next, the petitioner thereafter filed a petition under section 32C bracket 2 of the Act for recovery and realization of unpaid back wages, and also paid for computation of the same before the labor court. But the petition was registered as case number 2 of 2015. Next one. Case number 2 of 2015 was dismissed by the learned Labor Commissioner, Labor Court, by holding that there was no documentary evidence with regard to the entitlement for field allowance and no specific direction as regards the notional increment payable to the petitioner. The, no, the operating, the para 11 and 12 of the award dated 16/6/2016 passed in case number 2 of 2015 by the Labour Court. It is reproduced here and below as follows. Page 84, 85, 84A, huh? That's all. 10. That's 10, 11, 12. 10, 11, 12, it is, huh? Yes, sir. The petitioner's counsel submits that benefits, no, submits that back wages include the benefit of revised wages or salary. And the revision of and the yearly increment from a revised DNS allowance and other benefits. In support of the said submission, the council has relied upon the judgment of the Supreme Court, the case of State Bank of India and others versus P.J. Paul, 1999, 4 SEC 759. And in the case of Gammon India Limited versus Niranjan Das, BASF, huh? Das. 1984, 1 SEC 50. Next up, the petitioner counsel submits that the petitioner's back wages have been calculated as per his wage component given to him as on 18/4/1990. He submits that the wage component given to the petitioner as on 18/4/1990 would not have been the same in the year 2014. So there has to be a revision of pay and and payments of increment during the said period, during the period of 14 years that he was not in service. But 24 years, 24 years that he was not. I think that's all. Nothing. Next. Huh? That's it. And law also two judgments you relied upon. Huh? My judgment, what do you want? It's not a relevant thing. Next. No, no. The petitioner counsel. The phrase that the award dated 16/6/2016 passed by the Learned Labour Court Guwahati in case number 2 of 2015 should be settled. Direction should also be issued directing the respondent number 2 to pay back wages to the petitioner, after computing the increments and allowances due and admissible to the petitioner, along with interest with effect from 18/4/1990 till his wage date. Yeah, before that, huh? Is it right? The petitioner's counsel submits that on being reinstated into service, he was transferred to Mumbai. Correct? Yes, sir.
Yeah, joining Mumbai.
He was directed to join in Mumbai. Yes, sir. However, on reaching Mumbai, he was get out. He was threatened with
Yes,
threatened,
assaulted.
threatened and threatened with bodily harm. Huh?
They assaulted it.
He was assaulted by workers of the respondent number 2, due to which he fled Mumbai and filed a FIR in the Silchar police station. The Silchar police station thereafter sent the same to the concerned Mumbai police station for taking up necessary follow-up act. Correct? The petitioner thereafter, what? Thereafter what? He forgot about it.
No, to save his life, he came back to.
No, then you forgot about the FIR. What happened? You have no idea.
I was pursuing in Bombay, my friend. For what?
Thereafter, the petitioner
You need the money for that, my friend.
did not pursue
Due to pursue,
the FIR submitted by him.
due to financial problems, so right after that, Bombay advocate to engage my lord. That I have,
That you're submitting it. That'll be your submission.
that I have, that
He doesn't want to submit that.
my lord, I have written, please post me, join me to Nigeria.
Ah,
This document, allow me to join Nigeria, you put office there. Because Silchar office was closed. They rejected that, they are to go to Bombay. And it be Nigeria easily could appear there, comfortably. There, my, they tried to assault me, that's why I come back. It's a true fact. Fighting with this, Bombay is not easy from a person from Northeast, my lord. Okay. Here it looks like my lord, they done something. But the ticket person will don't get moved on.
I
He's
don't
staying in
know.
this air conditioned room.
I don't know this. Your new tanker seems to be doing very well. Republic. Is he Bombay is doing very well it appears.
So, 450 crores one person. 140 crores one person. No, no, sir.
Okay, turn back. Mr. Kane Chaudhary. The Lieutenant Senior Counsel for the petition of that the submission of a petition under section 32, 30C2 of the Act by the petition requires there to be an existing dispute between the parties regarding the amount payable by the payable by the respondent. But however, there is no existing, there being no existing dispute with regard to the amount payable by the one number. The petition filed by the petition before the labor court was mistake. We also submit that the Senate labor court has found no material to prove the case of the petitioner that there was evidence of pay or increment were payable to the petitioner. There was no infirmity in the petition. This the petition and the article and the petition 36 of the Mr. Continue. You also subject that in the absence of any specific directive as regards the notional increment payable to the petitioner, there was no, it was not possible for the executing force to determine the increment notionally payable to the petitioner. You also submit that One thing in your affidavit, you have nowhere spoken of revision of fee. You have only spoken of increment. But if it's first, that particular case, you can tell it. If it's right, it's not a survey. But whether it said that the increment, that the increment would be a revision. You can tell that. In your additional affidavit. अच्छा 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 ये सब करता हूँ submit that it in the uh, that in the respondent number 2 wage revision slash salary increment purely depends on the purely depends on the following factors A B C page 162 it happens that wage revision slash salary increment are given as a result of evaluation of an employee's performance as per policy. And on an individual basis. Submit that the same is not given across the board to every employee. It's up. The learner senior counsel the point number for the subject that the petitioner being absent from duty, or he cannot claim the benefit of notional increment for the during the period of his absence. So he cannot claim increment only because he has been reinstated into service with benefits of continuity in service. This regard he has relied upon the judgments of the Supreme Court in APS, RTC, and another versus S. NAFTA code NARSAGOUD reported in 2003 2SC 21 and in the case of APS, RTC, and others versus Abdul Karim 2005 6SC 30. Next, the learners will take class subject. Then we will talk about the point number 2 subject. That whenever a workman is entitled to receive from his employer any money or benefit which is capable of being computed in terms of money and which he is entitled to receive from his employer and is denied of such benefits from us. The workman can approach the labor court on section 33C bracket 2 of the Act. The benefits sought to be enforced under section 33C bracket of the Act requires a pre-existing benefit flowing from a pre-existing. However, in the present case, the petitioner not having shown any document to show that he is entitled to some pre-existing benefit of pre-existing like comma. There is no information with the system logic. Petition number section 33C that is relied upon. The judgment of the Supreme Court is State of Uttar Pradesh and another versus Big Falls 2005 8 SK. You also subject, you also start with the circular figure of the subject. Where the decision has to be made with regard to whether back wages should be awarded. It is necessary for the employee to be that he was not faithfully employed from the date of his termination. So only then will the burden shift to the employer. The benefit of that is it's not the case of the petition that he had not been faithfully employed. That he was not employed during the term, during the time he was under the during the time his service was service. Wasn't the stuff. It's not no use. Yes, Mr. P. Barrow, what is this judgment, 2007? How does it help you? 2007, 2 SEC. JK 630. No, not at all. See, that is not, so yes, that's the first instinct. That's something is not. Okay, that, as far as we have been told of the FIR filed by the petitioner has been quashed by the Bombay Act. Where is that? Huh? It is there. Give me. I have heard the past for the past. Any concluded judgment is no time. Huh? Right. Right. Right.
We have filed a reply in this matter. I think it is not on record. If it can come up on some other day for hearing, possibly on next Tuesday.
All of it I have got some.
Tuesday.
What is the case?
Cases regarding a tender. This is regarding that supply experience for that zinc sulfate. It has started earlier. Now, in my reply,
Let us see the NIT.
yes. Will also will come to page 29.
Yes.
Page 29.
Yes.
This is for procurement of micronutrients. And at page 63, will also will come. Page 63 is the particular clause which is relevant in this adjudication.
NIT dated 29/9,
And I did it 29/9. Yes.
page 63.
Page 63.
Yes.
Record clause 4.2.1. Record minimum experience.
Yes.
Now we are concerned with the micronutrients. Lots of you see that particular chart.
Yes.
The table, micronutrients number 1, zinc sulfate, heptahydrate 21.
Yes.
Now the clause Roman 2. If the manufacturer is participating in the bid, in that case, the manufacturer should have a valid manufacturing license of the quoted item and also should have experience of manufacturing the quoted items of not less than 3 times, which has now been modified to 2 times by a corrigendum. Quantity as specified for each item in the bid document for the last 3 financial years ending on 31st March 2015. Now, this is the clause that needs the interest. Now, as per
No, just a minute. So, clause 2 does not need, so this clause 2, so where the corrigendum dated?
corrigendum is
190. 90,
corrigendum dated 19/10/2023,
19, 10, 20.
wherein this 3 times has been reduced to 2 times.
Wait, okay, 190.
Yes.
Where? Clause 4.2.1.
Yes, lots of you will find it page 120. 120,
4.2.1.
4.2.1.
2. Is it?
Yes. Yes, 2. The clause is required minimum experience on the right hand side.
Two times.
2 times. Yes. This is not in dispute. Otherwise, also. Now, the
So,
issue is
so the issue with this, zinc sulfate heptahydrate 21%.
yes. So this is what is now what they have stated is that there has to be a manufacturing experience of 2 times of what has been asked for, the quantity that has been asked for. Now, if you also will come to the schedule of requirement, that is at page 65.
Chemicals manufacturing like profit curve, and not like the 3 times. Two times.
The relevant portion is the relevant issue which requires to be authenticated and also should have experience of manufacturing the quoted item, which is not less than 2 times. So there has to be a manufacturing experience.
So you
of that
should have manufactured at least 2 times the amount
Yes,
of
yes.
supply required.
Yes,
Ah.
sir. Yes.
So you should have at least 8,000 quintals.
No, it has the page 65 is the schedule of requirement.
Yes.
Page 65. Details of requirement.
Yes, 65.
Yes. Micronutrients, number 1, zinc sulfate, heptahydrate. The estimate quantity is 40,000, 20,000. So therefore, as per that clause, my experience has to be 40,000 I have to show. Now, to that regard, if your lordship will now come to what has been presented by us, is at page 195.
But why don't you say out here 4,000 quintals in this?
That- Yes, this is the minimum quantity of supply required within the last minimum quantity. But the tendering authority has considered it as 20,000. So we are not disputing that.
Okay, so they are supposed to have 40,000.
40,000
Manufactured.
of zinc sulfate.
So have you manufactured 40,000?
That's what I'm coming to. Page 195. What we have given in our bid.
Yes.
Now, if you also will see at page 195, this is what we have stated. Now, this is the declaration. How we have given. Number 1, we have stated regarding zinc sulfate heptahydrate and the production quantity we have given. And number 2, we have given zinc sulfate monohydrate and the quantity of production that is we have given. Now, if lordship adds both of them, it goes beyond 40,000.
Supposing the number 1 goes to how much?
Number 1 comes to 23,767.
How?
I have just calculated that.
How can it be? Must be more.
Nothing.
Like a production quantity and sales quantity.
Sales we are not
Okay.
concerned. We are concerned with only the production
Okay.
because they have asked for the manufacturing experience. What they are asking is for the manufacturing experience, not the sale.
So manufacturing, you have just got around, correct, around 23.
23,767. But what we have placed is along with that zinc sulfate monohydrate. And if lordship takes a comprehensive view, I'm coming to that. I know lordship. If lordship takes a comprehensive view, this otherwise goes beyond 40,000. That is the requirement. It comes to around 43,000. Now, why we have given this? Because zinc sulfate heptahydrate, zinc sulfate monohydrate is ultimately zinc sulfate. This is our case. And this case we are going to prove by the fertilizers control order to which they are themselves relying. If you lordship will see at page 65, just for a moment again.
65.
Page 65, just for a moment.
Yeah.
That details of requirement, just the line below that, the asterisk line, the above product should comply with the fertilizers control order. Page 65,
Yes.
below the chart,
Yes. Yeah,
there
not
is
product.
under 2 asterisks it is given, the above product
Yes.
should comply with the fertilizer control order of 1985. So therefore, what product they are asking for, it must be in tandem or in unison with what is there in that particular order, that fertilizer order. So that fertilizer order I have annexed in my reply. If a lordship will see that particular, no, the record. Now, yes, sir. The lordship is taking up the reply. The lordship comes to page 281. 281 is that fertilizer order. It starts there. Hundred 81 running page. So this is the fertilizer control order, and therein at page 311, kindly come to 311, is a schedule 1. Page 311. Schedule 1, which is the specification of fertilizers. 311. Down below, Lordship will see schedule 1, specification of fertilizers.
Yes.
And now Lordship will kindly come to page 336 and 339. Both the pages need to be appreciated in a corresponding manner. 336. And 339. 336 is the chemical structure or specification of zinc sulfate heptahydrate. 336.
Yeah.
So you have seen that. Number 1, zinc sulfate heptahydrate, to which they are saying that it has to be zinc sulfate heptahydrate. Now, if your logic will take that chemical definition, it is ZnSO4 dot 7H2O. What I have been stating is this is ultimately zinc sulfate with 7 molecules of water. Now, if your logic will just compare with page 339, wherein the chemical composition of zinc sulfate monohydrate is given. 339. So now Lordship will see again it is ZnSO4 H2O, that is 1 molecule of water, and thereafter if your Lordship will now compare what are the ingredients there. It is exactly the same.
I doubt.
Now, number 1,
Is matter insoluble. Okay,
matter
one.
insoluble in water, 1.
Like zinc,
Yes,
as per by weight, is 21.
yes, it
33.
is zinc. The percentage difference is only there. No, it is ultimately zinc.
Correct. So much.
The percentage difference is there.
So
What is the requirement of this of the employer or the tendering authority to see whether I can manufacture zinc sulfate with different varieties? I must say.
if you say copper wire, there's 5 mm, there's 10 mm, there's different mm. At the end, it's a copper wire. You'll be saying that.
That's what my argument is. At the end, what they have to see as me as a manufacturer,
No,
whether
you
I have
see
the
this, you
capability
see
to
this.
manufacture or not.
Okay.
The other component.
Now you see. One is the difference is in the weight. Correct.
Yes, this
Then-
percentage.
Yes,
is the
yes,
percentage.
that's in the weight.
Yes.
Now you come down and then you
Sulfur,
see
sulfur is 10.
where is the iron? Where is the iron in your zinc sulfate? Where is the iron? There's no iron.
There is one iron component is there.
Where?
No.
Where?
Zinc hyperhydrate is not.
There is no way.
There's no iron in zinc sulfate. Tetrahydride. Heptahydrate. There's no zinc. There's no iron. Then
1% of that is there. But others are saying,
we are not
no,
we
my
are not,
argument.
not chemists.
No, I'm not going to use a magnifying
Yes,
glass to dissect
we cannot do
what
that.
my argument.
And then another thing, let us go down slowly.
Yes, sir.
Let us see sulfur percent by weight minimum
15 and 10.
15. Now in this heptahydrate, how much is there?
10.
10. So there's a difference again.
but it's ultimately sulfur. It's sulfur and zinc. But the rest are no, Lordship, my all comprehensive argument would be, as a manufacturer, I need to prove that I have the capacity of manufacturing zinc sulfur of different varieties. Maybe heptahydrate or monohydrate.
Maybe.
So we had given it in a clear manner. That
You see, initially I remember when you first brought up this issue before this point. Your case was the only difference was in the the
Molecule of
water
water.
droplet, the
still
molecule.
remains. That's it.
That is only one component. There's no iron here. Your
Yeah.
sulfur by weight is also different. There's a whole lot of difference.
That difference will be always there because 21%, 33%. One is monohydrate, 33%,
Okay,
and one is 21%.
okay. Doesn't come. You can try a lot
I
for the division bench.
that is for the client.
Yes,
to
anything
decide.
else to do?
No, lots of only the principle of requirement, specified.
That's all.
Right.
So his bid was disqualified in the
Qualified
technical stage, technical bid.
Technically,
But then I have become the L1 if my prices are open because their prices are open now. So we
But
know
you are having the wrong item. They don't want this monohydrate. They don't want this iron, the iron part.
we are not going to give them the iron part, but we are saying that we have the capacity to manufacture. And by showing that, we show that we have to be able to manufacture.
Unfortunately, you could see, we have brought out the difference very clearly.
So the difference is only on that percentage.
No. Even one, this chemical content of iron is not there.
I think I don't feel the so.
Yes, very much.
I also didn't see this.
Yeah. Okay, right. Heard Mr. A. Sharma, Learned Counsel for the petitioner. Also heard Mr. B. Chowdhury, Learned Counsel for the Agriculture Department. Super. The petitioner given in this writ petition is with regard to the disqualification of his technical bid in pursuant to a notice inviting tender bracket NIT dated 29/9/2023 issued by the Director of Agriculture. Next paragraph. The specific case of the petitioner is that the requirement of experience for the manufacturer, like the petitioner, is met by the petitioner inasmuch as though the NIT requires the supply of zinc sulfate heptahydrate 21%, and the tenderer has to have manufactured 2 times the amount of the required materials to be supplied. The petitioner does not have the said qualification only in respect of zinc sulfate heptahydrate 21%. He submits that the petitioner manufactures not only zinc sulfate heptahydrate 21%, but also zinc sulfate monohydrate 33%. He submits that when the combined manufactured quantity of the petitioner for zinc sulfate heptahydrate 21% and zinc sulfate monohydrate 33% is taken, comma, the petitioner meets the qualifying standard required, meets the qualifying manufacturing standard, manufacturing requirement required, manufacturing experience required in terms of the NI. He also submits that as zinc sulfate heptahydrate 21% and zinc sulfate monohydrate 33% is more or less similar in nature, comma, the petitioner's tender, the technical bit should not have been discovered. That's all. Mr. B. Chaudhary, the learned counsel for the Agriculture Department, on the other hand, submit that there is a difference between zinc sulfate heptahydrate 21% and zinc sulfate monohydrate 33%. And as the respondents are the authors of the tender, comma, the disqualification of the petitioner's technical bit was correctly done as he did not have the requirement provided in the NIT. So I have heard the learned counsel for the first. As can be seen from the documents on record and the submission made by the counsel for the party. The NIT dated 29/9/2023 requires the bidders to have supplied
Page 63.
to have supplied to have the experience of manufacturing not less than 2 times of the quoted item. Three times, I think, no?
So by a coincidence,
Two times, two times.
Right.
In terms of the NIT dated 29/9/2023 and the consequent and the subsequent corrigendum dated 19/10/26. In terms of the NIT, 20,000 65 20,000 quintals of zinc sulfate heptahydrate 21% was required. As such, the petitioner was required to have the experience of manufacturing at least 40,000 quintals of the said chemical. However, the petitioner has got experience of manufacturing only 23,000 quintals approximate of zinc sulfate heptahydrate 21% during the last 3 financial years ending on 31st March 2020. So the petitioner's counsel submits that if you add the experience of the petitioner in manufacturing the zinc sulfate monohydrate 33% to the above heptahydrate, the petitioner meets the requirement of manufacturing 40,000 feet of zinc sulfate. The issue to be decided is whether zinc sulfate heptahydrate 21% and zinc sulfate monohydrate 33% are similar in nature. In this respect, the fertilizer control order, fertilizer bracket control order 1985, issued by the Government of India, Ministry of Agriculture and Rural Development, bracket Department of Agriculture and Cooperation. Page 281. Okay, 281. Shows the in Schedule 1, sorry,
Page 311.
in Schedule 1 provides for the specifications of fertilizers and their micronutrients, which is as follows. Ah, you see, at 336, we make a chart, zinc sulfate hydrochloride one set, and 339, 339, okay, zinc sulfate monohydrate, okay, next part. A perusal of the above chart shows that there is a difference in the zinc percent by weight in the above two chemicals and also in the sulfur percent by weight. In respect of iron percent by weight, comma, zinc sulfate heptahydrate 21% does not have any, no, in respect of iron percent by weight, it is found that the set micronutrient, comma, which is totally absent from zinc sulfate heptahydrate. The above clearly shows that there is a different composition in the zinc sulfate heptahydrate vis-a-vis zinc sulfate monohydrate. As such, this court does not find any ground to infer that the two chemicals are exactly similar in nature. The above being said, this is a matter for experts in the field. However, a bare perusal of the naked eye clearly shows the difference in the chemical content of the two chemicals in terms of the fertilizer bracket control bracket water activity. So further, in the case of AFCON, the Supreme Court has held around. Yes, Sarah, India, the reason said above, this court does not find any reason to interfere with the disqualification of the technical bit at the technical bit evaluation stage. That is accordingly.
Iron was maximum 1%. Maximum.
What is the rate order?
Interim order passed earlier, sir. So you argued vehemently. No, because you are objecting, thank God. Otherwise, I would have maybe adjourned the matter.
Okay, because the chief has to be.
I know. That's why I was also, I know because this rainy season.
Yes.
Actually, planting is usually May. May, June.
My instruction is that because of the heavy rain, if they plant the seeds now, it will get rotted. They will have to
Could
wait
be,
for that appropriate
It
time.
depends upon, you see, plain area, hilly area
Yes.
depends. You have some, they slow down. And some, so the rain might, the floods, it can happen. 2 years of looking at.
Okay, obliging.
Is there any point now? No, there won't be. Because you said now they must have already awarded the tender.
The RA process is not the reverse auction process is up to 6 p.m.
Okay.
to today. So if they do anything, they will do it tomorrow. Not today. Definitely.
What is this?
The basic I'll just before going into the entire matter. The basic is that that I am otherwise eligible to participate in the tender. What happened? I submitted my turnover, that is for the requirement is minimum 10 crore.
Let us see, where is the tender notice?
Lord?
Tender notice?
Tender notice. Your Lordship will kindly see page 26. Page 26, if your Lordship kindly in the middle, minimum average annual turnover of the bidder is for 3 years is 1,000 lakh. That is 10 crore. This is, my lord, then your Lordship will kindly come to last year. Time allowed for technical clarification during technical evaluation 2 days. Well, I'll make my submission on that, because they have not given any time. They have not sought for any clarification. If your Lordship kindly,
No, your technical bid was disqualified when?
well, on 10th of this month. 10/6. Then, the portal was kept open for 2 days. We submitted our representation on 11/6.
Huh? 11?
11/6. 10/6 our bid qualification, we were disqualified so far technical bid is submitted.
Okay.
We submitted our representation giving our clarification that the turnover given, they say that your turnover has been, you have been disqualified on the ground that you are participating as a partnership firm, whereas your turnover is of a proprietorship firm. That is,
What is the turnover of partnership firm?
a partnership firm is started from 1/4 million.
Huh?
In fact, it was a proprietorship firm of my father. The partners of this firm, the father was.
No, how much did you submit? Your minimum average turnover, how much was it?
That page 39.
Yes.
Page 39, your Lordship will find the, I have given 5 years. They wanted 3 years, I have given the 5 years.
So?
One of these all exceeds more than 10 crore.
No, you see, but it, for 3 years, did it cost 10 crores?
You know? 10, minimum 10 crore.
Huh?
Minimum 10 crore. One of my 2018-19 72 crore. 1920 68 crore. 2021 66 crore. Then
So this is for proprietorship.
Here is that my father was the proprietor. My father expired. Then mother and 2 sons. So during his lifetime, the partnership came into existence, but it was not proceeded because he was ill and all that. Ultimately, he died. Then the mother became the one of the partner in place of the father. The partnership continued. The entire business. The closure there that this entire business with all assets and liabilities will be continued
When is that?
under the partnership firm.
No. Why was your bid rejected? That's what I want to know.
The rejection, they said that you have given the turnover
Page 70.
70. Say 70. May read me now. Not meeting the eligibility criteria, reason specified in bid clause as per detail indicated in the comment. since the bidder offer has not qualified the para 1 of CEM bid and para 3 of CEM bid specific term and condition as per the documents submitted by the bidder, it is found that the bidder turnover which has been submitted cannot be considered for the bidder. Since the bidder has participated as partnership firm and the turnover details has been submitted of the proprietorship. But you know, they have not considered, they have not sought for any clarification because I was asked in clause 1 and 3 to give a Milord turnover certificate from a chartered account. I have given a turnover certificate from the chartered account. Now, Milord,
You
Up-
participated in the partnership firm.
that's true, Milord. There is no dispute to that.
And turnover detail have been submitted of proprietary firm.
Property firm,
What is
Milord,
wrong?
because just prior to that, Milord, the property firm was continuing with the business. Thereafter, Milord, they have converted it to a partnership business. And Milord, we submitted a representation. That, my Lord, is page 79.
Yeah.
My Lord, your Lordship will find, we would like, the second paragraph, we would like to bring to your kind notice that our firm Assam Supply under the same name has been converted from proprietorship to partnership as a going concern, and all assets and liabilities, including income tax and GST, has been taken over by the from the proprietorship to the partnership. Therefore, the turnover submitted at the time bid must be considered. And accordingly, Milord, further, no documents relating to construction firm was required. As per the bidding documents, therefore, only required document as per the tender was submitted along with the document. So we gave
Where are you reading? I don't know.
one of the page 79.
Yeah.
Second, annexure 5, para second paragraph.
Yes.
You would like to bring to your kind notice, my Lord,
Yes, yes.
that Messrs. Assam Supply Syndicate under the same name has been converted from proprietorship to partnership as a going concern, and all assets and liabilities, including income tax and GST, has been taken over from the proprietorship to partnership. Therefore, the turnover submitted at the time of the bid must be considered. Next.
When did you transform into a partnership?
The deed was made on 14/2, Milord. 14/2/2024. The first deed was made on, Milord, 1/11/2023. When the father was alive.
So when did your father die?
Father died in Milord on 17/1, January, 17/1/2024. I have given the certificate here also, Milord, the death certificate. That was also.
So you had
And
enough.
thereafter, Milord, the firm was reconstituted, partnership was, mother was inducted in place of the father.
When was that?
That was, Milord, on 14/2,
14/2.
14/2/2024.
But you said there is a partnership firm. How can it be? It was earlier a proprietorship firm of.
Earlier it was a proprietorship.
Till when? Till when?
Till Milord, it continued till 31st of March, Milord, 2024, under the proprietorship.
But then you said this partnership came into being
Milord,
when?
Came into existence from 1/4, so the deed were made earlier,
1/4 of?
2024. It was given effect to.
Then you had 2 months to change into whatever.
Huh?
You had 2 months time.
Milord, may I just do your notice the censor to the deed?
Huh?
The deed of partnership. I have annexed it.
Yes, what to do, madam?
There's 110 plus.
I'll come to that. 110, Milord, my representation was, Milord, not considered.
That is rejected.
Not rejected, Milord, they said it cannot be considered. Milord, may I read? They said that 109. The bidder has participated in the government bid with the specific authorization from so and so. The original offer of the bidder has been deliberated on the basis of the government bid conditions and offer submitted by them. Accordingly, this qualification has been communicated to them. That, Milord, 10/6. The bidder has submitted annual turnover certificate which was not found to be relevant for the bidder, and accordingly this qualification has been communicated to the bidder. Now the bidder, along with their representation, has submitted additional documents. It is to be mentioned that instant bid has been published on ISNA and opened on 19/4/2024. All the bidders were having an opportunity to submit their bid complete in all aspects as per the terms and conditions of the government bid. In this case, after disqualification has been communicated to the bidder, they have submitted additional documents. From the above, it is evident that the bid submitted was not complete and was having shortfall document, which has been submitted by the bidder with representation. Since the additional documents has been submitted by the bidder along with the.
Yeah, so with the representation.
That 11 Milord. That Milord, I have read that 11th of June.
Yeah, from the above, it is evident that the bid submitted was not complete and was having shortfall documents which has been submitted by the bidder with representation. So you submitted those required documents with the representation.
No, Milord, that's what Milord.
Huh?
After he was found.
After this,
Milord, then in that case, Milord, I'll take my note to the Milord bid conditions, what I am supposed to sign. My Lord will kindly come to page.
we'll take it up tomorrow.
You know?
We'll take it up tomorrow. Nothing will happen. Yeah, I thought.
We are only required to, Milord, give it, Milord, certificate from the chartered accountant.
Only matter.
But, may just point out one thing. The RA will be over by 6 p.m. They may, Milord.
No, you have also come when
No, Milord, I have not made, Milord, 14/6, I was informed in the night, Milord. 15, 16 and 17, Milord, all holidays, Milord. I have come, Milord, just after, Milord, without, Milord, taking any time.
but then I don't find that much of a case in your favor. If you have a
I
case
satisfy my Lord.
tomorrow, no, not. You can't be here whole life.
Only, Milord, if your Lordship, my friend can give an undertaking that they will not, speak further.
Can I, so this is an update. So it may be taken up for.
Milord,
Tomorrow we'll take it up.
can you, Milord, Milord, the first item,
You make a mention to
or I'll make.
after motion.
Huh?
After motion.
After motion, my Lord may give indication to list the matter tomorrow.
You just no. Now it will come in the supplement. That tomorrow this is already out.
That's I know, Milord. Supplement.
You make a mention tomorrow. You make a mention tomorrow. You make a mention tomorrow. We'll see.
It will be listed in supplementary list.
Yes, sir.
Okay, at 10:30, I'll make it.
Okay.
Wait, Lord. My Lord, NIT Railway and may I take your Lordship to page number 53? The reason for rejection.
Yes.
Your Lordship, in the remarks column,
Page.
page number 53, Your Lordship.
Yeah. Oh. Tomorrow.
My Lord, I pray your Lord.
List of works in progress of which the value was not certified. Not certified by chartered accountant.
Yes, but it was certified and we have already submitted. We have annexed this, there's an annexer here, annexer is.
No, that is after your rejection, probably you have to connect.
No, your Lord.
That's what has been said.
We are a seasoned contractor here, so we know what, when to, what is something. But the real issue to work.
This is a issue that is a factory. We'll see tomorrow. Hopefully. The other side is not here.
The work order will be issued today.
This thing. Can't have it. Sometimes. Why should I doubt what they say? We'll see tomorrow morning. Can always be staged.
Let's make it next week.
Yes. This is the matter tomorrow.